Good morning. If the AHO team would please, we already have done one. It looks like there's one more court reporter link to be elevated. Oh, maybe we have.
Hello.
Good morning.
Good morning.
If we can please, I'm looking to the AHO team, elevate both court reporters to panelist status. And I believe we have one more.
Thank you.
There she is.
Here we go.
Excellent. And then with that, are you ready for us to go on the record?
I am ready.
Thank you
Thank
very
you
much.
so much.
Good morning. It is April 24th, 2025. I am Nicole Kinsey, presiding hearing officer for the Administrative Hearings Office of the State Water Resources Control Board. This is the hearing on the pending petitions for change of water rate permits 16478, 16479, 16481, and 16482 of the Department of Water Resources for the proposed Delta Conveyance project. I am conducting this hearing in accordance with the July 31st notice of public hearing and subsequent amendments. The hearing this morning is being conducted by Zoom webinar. As typical, if you are planning on actively participating today, you will need to log into the Zoom webinar using the individual link that was sent to you by Zoom. If you are having any trouble communicating with us today, or having technical difficulties, please send an email to dcp-wr-petition@waterboards.ca.gov. We are broadcasting this hearing live on the AHO YouTube channel. Both the audio and video of this hearing are being recorded, and we will post files of this recording in the FTP folder for this proceeding, and the YouTube recording will also be available on the AHO YouTube webpage. We will follow our usual schedule today, assuming that we go all day. We will have a hard stop at 5 p.m. As I have done, I will simply call for appearances for the first time that you seek to speak. And I think we're getting into a routine on that, so we all know how that works. Ms. Mullen is with us today and will be handling exhibits and screen sharing. And if you are cross-examining an attorney, you are welcome to address Ms. Mullen directly to bring up a particular exhibit. I believe today where we left off, turning to our substance, is that we are convening now at 9 a.m. to address the procedural matter that has come up related to the representation of certain protestants. My intent is to turn first to DWR to get an update on where things stand and propose next steps, and then we will move on from there. I think it probably makes sense to go ahead and take appearances from several parties who I assume will be speaking. So let's go ahead, please, the AHO team, if you would elevate Ms. Carroll. I'm assuming, oh, you're already elevated. Good morning, Ms. Carroll, please.
Good morning, Hearing Officer Kinsey.
Thank you. And then let's please also elevate Mr. Ferguson. And Mr. Ferguson, you're welcome to make your appearance.
Good morning, Aaron Ferguson on behalf of County of Sacramento, Sacramento County Water Agency, City of Stockton, Sac Sewer, and Byron Bethany Irrigation District. Thank you.
Thank you. Good morning. And let's please elevate Ms. Tabor.
Good morning, Hearing Officer Kinsey, Kelly Tabor, Somac Simmons and Dunn, also on behalf of the same parties as Mr. Ferguson.
Thank you. And please elevate Ms. Morris.
Stephanie Morris for the Department of Water Resources. Sorry, while we are elevating people, I did send an email. Mr. Singh is having issues with his link, and we're hoping we can get a new link while we're working through these procedural issues, so as not to cause potential delay. But I did send an email to both emails.
Thank you. Excellent. I see Mr. Singh is here as an attendee. Is there still an issue?
Yeah, he's not able to join. So it says he joined, but we can't find him on any of the screens. And so, and we've closed out everything. And I think we need a new invite because he is there. So it won't let him actually join. I understand the irony of that it says he's there.
No, I certainly believe you. I'm trying to think how to do this. I think we may need to send a link to a different email address because they're email address specific. So that's where I'm brainstorming how to do this. I will look, maybe I'll think of, thank you for raising this now.
Or maybe you can kick him out of the meeting. He might be able to rejoin, perhaps. And that might solve it.
I think he's gone now. It looks like and I'm just getting messaged in real time. So maybe try again. And if that doesn't work, we can, if you maybe email us someone else's email address. I don't know if there's a general email address that you might use and we could send
email that I sent could be used. It's a different email, so we could use that in the event that we cannot solve this issue in the way we're trying now. Thank you.
Excellent.
And sorry for the interruption.
No, thank you for bringing that up now. This is it's good to work on that. With that, maybe I'll turn first, Ms. Carroll, to you to give us a summary of where we are before I ask whether there are others who will want to participate in the discussion, because you can tell us where we are and the scope of this discussion. So I will turn to you for an update, please.
Sounds good. I think I'm just going to launch right into the issue and give you our positions to hopefully make things go efficiently. So lawyers and law firms have standards and duties that they must abide by to ensure fairness and justice to past, current, and future clients, and including a duty of loyalty to former clients. Somac Simmons and Dunn is operating under a conflict of interest by representing parties adverse to DWR's interests because one of its lawyers, Casey Shorrock, previously represented DWR in a substantially related matter. Ms. Shorrock has participated in a way that her prior representation of DWR, she obtained confidential material regarding the necessary activities to support development of the Delta Conveyance project design and alternatives, and the development of the CEQA litigation strategies for the geotechnical work and for the larger Delta Conveyance project. She did this while employed at the law firm Remy Moose and Manley. It is a long-standing client. DWR is a long-standing client of that firm. And it is that firm's belief that her work for them is work that was against DWR. And therefore, she was advised that she would be prevented for working on behalf of the clients of the Somac firm. As soon as DWR perceived this conflict, which was on April 9th, after Ms. Shorrock conducted her brief cross-examination of our witnesses, we diligently began investigating whether or not this was an actual conflict. We immediately contacted one of the associates at Somac, and we began talking to them about the issue to determine that a legitimate conflict existed. Should be noted that DWR was never advised of Ms. Shorrock's change in employment from the Remy Moose Manley firm to Somac Simmons and Dunn, and a waiver was never previously requested. Since we've discovered the conflict, our DWR legal team has been spending its nights and weekends working with Somac and its outside ethics counsel in good faith in an attempt to reach a resolution. And as we stated yesterday, we have not been able to reach a resolution, and that still stands. And that's why we felt that we had no choice but to pursue our rights and remedies and raise it in this forum. But we also recognize the importance of this Delta Conveyance project and the importance of not creating any delay. And although allowing SOMAC to continue their representation of their clients in this hearing, and it prejudices DWR, doesn't prejudice anyone else, just the department. We can't allow this egregious behavior to delay one of California's most important climate adaptation projects. Thus, if you are willing to continue to allow the hearing to proceed on schedule, DWR is willing to waive its remedies against SOMAC with respect to the conflict in this hearing and any subsequent appeal or litigation resulting from these proceedings. But we will continue to pursue our rights and remedies with respect to the conflict in other appropriate forms. That's our proposal for keeping things on schedule.
Thank you, Ms. Carroll. And then I will look to Mr. Ferguson or Ms. Tabor for any response to that.
Well, just to make sure I understand, it sounds like DWR is dropping the objection at this point in this forum. Is that accurate?
Only as to this forum, correct.
Okay,
And
so
only
does that mean there's nothing
if we stay on
for
schedule.
Ms. Kinsey to act on? Frankly, you're dropping the objection and we move on.
Here, yes.
Well, that's all Ms. Kinsey has control over. So if it's clear that you're dropping the DWR is dropping the objection and it's effectively with prejudice, this issue won't come back up again in this forum. Then we move on with Ms. Tabor's cross-examination and deal with the issue in any other forum that DWR believes it's appropriate to bring this issue up in again.
And let's be clear, we're not dropping the objection. We're waiving our right to pursue a remedy and have Ms. Kinsey have to rule on the matter. We believe there's a standing objection, but we think that the hearing should proceed. It's up to you whether or not you would like to proceed with that objection standing.
Okay, I think waiving the right works for us, and so, meaning DWR will not bring this back up again in this forum. That works for us.
To clarify, the department is not seeking to or will not seek to strike any testimony elicited by our firm in cross-examination or any testimony by our client's witnesses in this proceeding.
I think I was clear, although we don't think that the cross-examination is an issue.
So it sounds like you have not had a chance to discuss or think about this issue before. I think it would be fair, Mr. Ferguson and Ms. Tabor, if you want to take a moment, as in a break of some kind, and consider this and whether you have any concerns. I do want to make sure this is clear for all the parties going forward so that there is no confusion and this doesn't resurface as an issue that we have to deal with later.
I appreciate that. Sorry to interrupt you. I think that
we had an opportunity to discuss this with our clients. This is the first time I'm hearing about this today. So I don't see how that we can go forward without the opportunity to confer with our clients and obtain authorization for that. So our position, as we stated before, is this hearing cannot go forward until this issue is resolved.
Ms. Carroll.
This is a waiver in this hearing. This isn't a proposal to their client. This isn't an offer to settle. This is a proposal to make sure that we stay on schedule in the current proceeding.
It defies logic, Hearing Officer Kinsey, that the department could assert and waive a conflict in a proceeding that they claim is so inextricably interrelated to all the other litigation cases that they are involved in with our firm that involve this project. So I'm not prepared sitting here today to represent that our clients could agree to this. They're not presently, apparently they don't see a conflict in these other proceedings, but I don't have any information about that. And I just don't see how this hearing can go forward until this issue is, we can give you a definitive response on our end.
Well, let's do this. I'm not sure. I mean, given that the motion before me is withdrawn and there's nothing left to act, my inclination is going to be to go forward, but I do want you to at least to have a moment to think about this. What
Yeah, I
I'm
would
considering
appreciate
is we would
that.
break until 10 o'clock, come back at 10 o'clock, and then we can more clearly articulate where we are. I think Dr. Priest is not available until 10 o'clock anyway. So that may work, but that's what I was considering would be to at least give you an offline moment to confer. Ms. Carroll, did you have something to add to that?
Yeah, I just wanted to make clear, we didn't have a motion on the record. We had provided notice that there was a conflict issue. Yesterday, it came up that we could not reach a resolution. We said we would come here today with a proposal as to how to move forward. Our proposal is that we not waive the conflict, but that we waive our right to seek any remedy or require or request that you make a ruling on the matter here. This isn't a settlement offer. This isn't something for clients to consider. This is procedural and should be a decision as to their clients can choose their right to representation and who they choose to represent them.
Yeah, just so I'm clear, Ms. Carroll, you're saying DWR waives the right to raise the conflict issue in this forum.
We waive the right to seek a remedy of the conflict issue in this forum.
And for my clarification, in this forum, before the State Water Board, does that include any appeal of any decision by the State Water
Yes,
Board?
any appeal or future litigation that results directly from these proceedings, this waiver stands.
This waiver to objection, but not waiver to the asserted conflict.
Correct.
All right.
But in short, that effectively means that the way I'm understanding it is that DWR cannot raise this conflict issue to seek any sort of to support any sort of request on any issue in this forum. Is that correct? With respect to testimony, like Ms. Tabor brought up, with respect to cross-examination, with respect to any sort of relevant matter in this proceeding. Is that accurate?
Yes.
Okay. Okay. Yeah, I think if we could have a few minutes to talk and we'll come back. If we could come back at 10, that'd be great, Ms. Kinsey.
I think that makes sense. So and thank you to all of the other participants for your patience on this. Let's go ahead and take a break. We will reconvene at 10 o'clock. We will hopefully be able to resolve this issue. And my intent, depending on how that goes, would be to pick up with cross-examination of panel 2 at that point. It looks like we have hands. Ms. Desjardins, I think you're first. Please, if we can elevate Ms. Desjardins and you can provide your appearance. We may have gotten Mr. Moore first. Mr. Moore, you're welcome to go first. If we can also, in the background, please elevate Ms. Desjardins. Good morning, Mr. Moore.
Good morning, Roger Moore, on behalf of Protesting California Water Impact Network. At the end of yesterday, the question arose about whether this is a matter simply between the SOMAC firm and the protestants they represent, or whether it has consequences for others. Mr. Keeling took the position that it does have quite important consequences for others, a position that CWIN strongly shares. I do not want to get in the way of progress, and I'm glad that there will be an orderly opportunity for counsel from SSG to contemplate the matter and come back. But I'd like to get a bit of clarification because CWIN and apparently others do believe that the way this is handled and whether it is handled in an inconclusive way may have negative and prejudicial consequences for others. So I guess I'm wondering, as a matter of procedure, should we break now and then come back with the understanding that all of us will have an opportunity to weigh in at that time? Or is your preference to hear from me or others before we break? I think probably the former would be more constructive, but I will abide by however you would like to handle that.
I believe the former would be the more constructive, that we will break now, come back, hear from, I think, Mr. Ferguson and Ms. Tabor, and then from any others who may have comments on whatever resolution, wherever we are at that point.
Thank you. I appreciate that clarification.
Thank you. And Ms. Desjardins, you're welcome to make your appearance and your comment.
Thank you very much. Deirdre Desjardins, California Water Research. I wanted to ask, with respect to my cross-examination, there was an objection raised by the Department of Water Resources, and I did go ahead with my cross-examination out of order. And so there is a question, is DWR withdrawing their objection at this point to SOMAC Simmons and Dunn proceeding? And if so, will Ms. Tabor go in order and then I'll pick up afterwards? It has affected the order of cross-examination, and there is a question of the entire hearing proceeding with that question outstanding. So I'm just not clear, given that an objection was raised on this and this was supposed to resolve it, how that's going to be resolved if SOMAC Simmons and Dunn need to go back to their clients to resolve it.
That's what we're going to reconvene at 10 o'clock and talk about. So we will have more clarity. And Ms. Desjardins, so you are aware, assuming we go forward with cross-examination, I had given you the option of either completing your cross or waiting until after Ms. Tabor conducted her cross, and that offer continues to stand, that you can make that decision.
Okay, thank you very much.
Ms. Carroll.
I just wanted to clarify that our willingness to waive is conditioned on the continuance of the hearing and staying on schedule without delay. And I do want to clarify that the other appropriate forum for bringing this is in the existing litigation to which many of you are already involved.
Thank you. Thank you, Ms. Carroll. All right, I believe now let's please go ahead and we will break and we will reconvene at 10 o'clock. And if you would please stay in the room, it'll just be a long break. Thank you. See you then. All right, welcome back. I will look first to our court reporter. Are you ready for us to go back on the record?
Yes, hearing officer Kinsey, I am here.
Thank you. And I see Mr. Ferguson and Ms. Carroll, so I will turn first to you, Mr. Ferguson. Would you like to provide us an update?
Yes, initially, I do want to make clear that the firm and our clients dispute that a conflict exists, and just want to make it clear that we vehemently disagree with the comments of Ms. Carroll earlier this morning with respect to the conflict issue. Nevertheless, based on what we understand DWR to be offering in terms of a waiver to waive this issue in this forum or any appeal of any order that may come out on the change petition, we're comfortable, we won't stand in the way of that proposal and are prepared to move on with the proceeding.
Thank you, Mr. Ferguson. Ms. Carroll, I don't know that you need to respond, but is there anything you'd like to say as well?
Only clarification is we are waiving as to pursuing the remedy, just to make sure that's clear.
And I will look to the room. I know I had allowed for others to comment if they would like to. Is there anyone who has anything else to say on this issue? Otherwise, my intent would be to pick up with cross-examination of panel 2. Mr. Cho, if we can please go ahead and elevate Mr. Cho because we have not seen him yet today. Good morning.
Good morning, Hearing Officer Kinsey. Thank you. And, my intent with these points is not to meddle in any decisions that are made either by DWR or by the SOMAC firm on this. This is more of some points of clarification for the other parties who have been, as has been referenced at other points yesterday and prior, that have been coordinating with the SOMAC firm and also maybe participating in the ongoing concurrent CEQA litigation relating to the DCP. So a couple of just clarifying points, and maybe Ms. Carroll can respond or not. One, I don't think that DWR has acknowledged the fact that Ms. Shorrock's participation in this hearing has been noticed since at least August of 2024. Ms. Carroll said that they diligently responded after April 9th when Ms. Shorrock actually appeared to conduct cross-examination, but I think that's not a full accounting of the facts that are relevant to this issue. Second, it's not clear from, well, I think Ms. Carroll has tried to clarify this, that DWR is not waiving its objection, but it's waiving its right to seek remedies in relation to an objection. But as far as I'm aware, there is no objection. I don't know if that means that DWR is still planning on raising an objection later, or if it believes that such an objection is standing currently. But I think that could be clarified. And then lastly, I just think that this stance that DWR is taking is a little nonsensical. And I'm just curious how it makes sense if DWR is going to pursue disqualification in the CEQA proceedings, how SOMAC could continue to represent its clients in the HO proceeding if there is a disqualifying level of conflict that DWR perceives there to be. Thank you.
Thank you, Mr. Cho. I think let's clarify. I think this issue came up about the status of an objection and whether there's an objection. So maybe let's just have a brief exchange about this. My recollection, and I have not looked at the transcript, my recollection from Tuesday is what occurred is that Ms. Carroll made a motion, if you will, or a request to postpone Ms. Tabor's cross-examination of the panel 2 witnesses. And I believe I granted that request in part by stating that we would not conduct cross-examination from Ms. Tabor on that day, on Tuesday afternoon, but that we would pick up with the issue this morning, the 24th, and address it. So that is my understanding of what was actually in terms of the action of the AHO, and that would have been one of the questions today, was whether there was a more, something other than a request to extend postpone Ms. Tabor's cross-examination. I think that was the only thing that was on the table. But Ms. Carroll, does that fit your understanding as well?
My understanding is that we did object to SOMAC's participation based on the perceived conflict, and that the request to delay Ms. Tabor's cross-examination was based on the attempt to reach a resolution to see where we could go forward from there. But the objection, I believe, still stands.
All right, thank you for that clarification. Mr. Cho, do you have, well, Mr. Ferguson, please, you haven't had a chance. Do you want to jump in on that issue?
I'm not really,
Yeah.
I'm just thinking about, I'm not really sure that the objection is efficacious when we're speaking to an issue like this, because it's the issue they're raising and what is different from an evidentiary objection. So, I mean, they can, from our standpoint, they can quote unquote object on this issue, but it really, it's just that. And I don't know if there's anything, frankly, for you to act on in that regard.
I think that's right. I assume, I mean, just to be perfectly frank, and Ms. Carroll, you can correct me. I assume that the maintaining the objection has to do with making sure that you're avoiding any waiver in any other forum of this issue. And not that you're asking the AHO or the board to take any particular action. Is that accurate?
That's accurate.
Okay, thank you.
Well, then I will say then that's something that we would stand in the way of, because my understanding is that DWR is saying that they will not seek the remedy of disqualification based on a conflict in this forum or in any appeals related to issuance of an order on the petition. That's my understanding of what they're proposing.
And maybe a point of clarification on that, I think when I said another forum, and you're right, that was unclear. Maybe Ms. Carroll, can you clarify, did you intend, you meant with respect to other lawsuits not directly related to these water right permitting proceedings?
Correct. Other litigation that doesn't arise out of an appeal or other litigation related to this hearing, the change in point of diversion.
Okay, thank you. Thanks for that clarification.
And thank you for this exchange. I do want to make sure we're as clear as possible on the record. Ms. Desjardins.
Thank you. I did want to say that my recollection was also that an objection to Ms. Tabor's cross-examination was raised on the issue and the issue of participation of Somac Simmons and Dunn in the proceeding was raised. And that was why I stated I was uncomfortable with an outstanding due process issue is simply that proceeding when a party's counsel is not able to do cross-examination, that objection has been raised. It creates a due process issue for the entire hearing. And I am concerned that this offer is being made verbally, and the clarifications are verbal, and there isn't a transcript available. I assume DWR is going to make the transcript available, but it needs to be very clear exactly what's agreed to. If nothing else, because as Ferguson said, if DWR came back and tried to disqualify Somac Simmons and Dunn's participation, it would cloud the entire hearing. And this is a huge effort by many parties. So I just want to be sure that the issue of Somac Simmons and Dunn's participation in their representation of clients for purposes of due process, like cross-examination, is not clouded. And that objection has been raised and it hasn't been withdrawn. Thank you.
Thank you, Ms. Desjardins. And just to clarify, that's my understanding is that DWR is waiving their right to pursue any remedy with respect to that objection, with respect to this particular proceeding. Let's go ahead and there are a number of hands. I don't know the order. Mr. Moore, let's proceed first if you would like to speak first, and then we'll move to Mr. Spain and Mr. Krieger. Maybe Mr. Moore didn't have a hand. If we can please elevate Mr. Spain. Oh, I'm sorry, Mr. Moore. You made it. I was maybe too quick. Please, if you would like to speak, you're welcome to.
Since you called in Mr. Spain, it's fine with me if he proceeds first, and then if I can, I'll go next.
Okay, Mr. Spain. Good morning.
Yes, in light of the cloudiness of some of this, obviously, I urge the parties to put some sort of joint statement together in the record, in writing. Otherwise, we do have some ambiguities, and in that process, you know, the old saying, if it isn't in writing, it didn't happen. We really need to have something that's firm and that we can rely on as we proceed in this. Otherwise, we may be wasting our time.
And this continue. I will foreshadow, I think, and we can have an exchange about this. It does seem to make sense that we have something memorialized in the record in writing if DWR and the SOMAC firm are able to do that. It can be very short, but I do anticipate if this were to come up again, a court would appreciate having a clear meeting of the minds with the written word.
And in that process, there may be some ambiguities that we can squash up front.
Right, which is helpful.
Well, let me just offer, Ms. Kinsey, I don't see a need for our firm to agree to anything in writing, and I wouldn't envision us submitting a joint statement. If DWR wants to submit a statement clarifying its waiver, that's fine.
That makes sense.
We don't see anything
that makes
we
sense.
need to agree to.
That makes
sense. It's their objection. Yes, that makes sense.
Ms. Carroll, does that would that be? Do you have any comments on that approach to have something it can be very brief, but something in writing from DWR?
No, I think we've been clear on the record here. There is a transcript, there's a video we can go back to review. There's a very clear record on what DWR is agreeing to do, and that's to waive its remedies, to pursue the conflict in this hearing forum, and also in any appeal or litigation directly related to the outcome of this change in point of diversion hearing. So we've made this very clear as to what we're agreeing to, and I don't think that it would behoove anyone. It would just be inefficient to continue to have to argue over this. I think anything we put in writing will be disputed.
That is the point.
Mr. Spain, thank you. I'm going to jump in on this. Ms. Carroll, I think it can be almost, maybe it is. I'm not directing you what to write down, but verbatim what you just said in an email, we will have it in the record. Yes, we have the transcript. Yes, we have these things. But I think that would be helpful for us, and we will go from there. But it's the same as, you know, what you just said. It can be an approach. So please do submit such a writing to the AHO. We will include it in the record. If we can please elevate Ms. Meserve. Oh, I'm sorry, Mr. Krieger. You had a hand and then you didn't have a hand, and I forgot.
Yeah, thank you, Hearing Officer Kenzie. Just for the record and very briefly, I want to say that the state water contractors are pleased that the hearing is going to move forward and that DWR will be addressing this in the appropriate court venue, and we support that.
Thank you, Mr. Krieger. And Mr. Moore, I inadvertently skipped you too. I apologize. I got distracted.
No worries. I have great respect for the SOMAC firm, one of our best and most respected firms who should not be impugned in this forum. And I can't address the evidence that they have directly because they haven't presented any. But I do want to focus my remarks on what Mr. Keeling started to raise last night, which is the potential consequences for other protestants of potential loose ends. And so I hope we can navigate this through in an expeditious but a clear and conclusive way that does not leave wiggle room for this to blow up later and have unintended consequences. I think that I understand the position of where DWR is now, that it is not waiving the objection, their belief anyway, that there is some sort of conflict, but they are not pursuing the remedy here. And they are also agreeing not to raise it in any litigation. I think the phrase was, although I may have a word or two off, directly related to the to this proceeding. I'm a little worried that they may be burying the lead here about their future intentions to um uh uh to use this in a way that could be prejudicial to many of the protesters who are also involved in litigation. So the for example, there's a question here about what the related litigation is, or could be. Is the litigation in which they are deciding not to raise it simply a potential challenge to the state board's decision on the change petition in this proceeding? Or does it also extend potentially to other matters related to the DCP? The SOMAT firm is not only highly respected, but also has been very successful in litigation that is closely related to the Delta Conveyance project, including a challenge in which there's been a preliminary injunction and a validation proceeding that the DWR lost. So can we have some assurance that when they say that they are not going to raise it in related litigation, that it applies not just to a potential challenge to a decision on the change petition, but also uh, 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 to not pursue that line, or take some strands from this proceeding to use in other litigation related to the Delta Conveyance project, such as the examples that I mentioned.
So, Mr. Moore, can we pause there, because
Sure.
but and this is outside of my wheelhouse, because what's happening in the other litigation is not directly I think an area where I ought to venture. But my understanding of what Ms. Carroll represented is no, they are not waiving their opportunity to raise this issue in other litigation related to the Delta Conveyance project that does not directly arise out of this water rights proceeding. Ms. Carroll, do you have anything to add to that clarification?
I do not. You are correct. Thank you, hearing officer.
So I don't know if that, Mr. Moore, if you have, I didn't mean to, I interrupted you in the middle, but I wanted to make that clarification. I do not think that DWR has waived that opportunity for a remedy.
I just want to try to make a few other points here. I mean that is of concern because there are joint efforts in litigation. Again, it is the SOMAC firm's prerogative to proceed as they see fit. It seems to me that there is an easy resolution, easy to me at least, others may disagree, just based on what was set forth in this proceeding and what was not. In this case, it's unclear from what I heard whether there was a motion, quote unquote. There was an oral request that was made a couple of days ago in one of these proceedings without evidence or written argument, or showing that the hearing officer had the authority to act on the request that they have now withdrawn. um, I have, I'm very concerned about the position of DWR that all depends on proceeding today, because it's so important to expedite these proceedings. It seems to me to be transparently clear that um, that um, the problem with timeliness is on DWR's side. There's a self-inflicted error here arising from the fact that the um, uh, they were notified through an NOI filing, I believe, last August, that
So,
the
Mr. Moore,
attorney
we've
in question was
been
involved.
through some of this morning already, but I would ask respectfully, what are you asking of me? Why are we having this conversation?
Um, Having conferred before this call, we wanted to make clear that um, we supported the position of that the SSD Council had articulated, that the motion, if that's what it was, should be overruled, um, and no longer a part of this proceeding, or we would need to pause. So we have we now have a motion request, whatever it is, that was waived, but not in a way that waives the objection, which makes us concerned about what to use about it. It also, the direction that I got from my clients was, unless there's a conclusive resolution of this, and that that we should not be in a position of proceeding with cross-examination today. We should have an opportunity to discuss the implications of what has been set forth. I'm not going to have an opportunity now to go back to them. I recall that on previous days, at least one protestant, maybe others, mentioned that they would need to, uh, they would want to reserve the right to um, request additional cross after Ms. Tabor, because of the change in ordering. So I guess what I'm wondering is, if Ms. Tabor wants to proceed, that I understand, and I don't want to get in their way, but I think, given the strands that have been thrown out here, that it might be helpful to have a pause in the remainder, so that the rest of us can confer with our clients, and have an orderly way to discuss the implications of it, and resume our cross on another day.
So, Mr. Moore, my understanding, I'll let Ms. Carroll speak for herself. First of all, once again, I realize that the other parties have an interest in this proceeding, moving forward in an orderly way, and that us coming to a final resolution, the State Water Board coming to a final resolution that is based on a fair proceeding that will stand up in court. Everyone has that shared interest. My understanding from Ms. Carroll is that this offer is an exploding offer, if you will. And if we don't go forward on the timeline, and this is, I'm not pushing, we can stay the proceeding, we can continue. But my understanding is that the offer is a exploding offer. So I think you're faced with the choice, and your clients are faced with the choice, if I understand, that we either go forward today with, as Mr. Ferguson and Ms. Tabor has indicated they're willing to do, or we move this matter off to court where I think it belongs, not with me. I don't think anyone wants me to decide this issue, although I think I'm a little unclear as to what you just asked me. It sounded like you wanted me to address the objection, which I don't think others want me to do, and I'm not particularly inclined to do, especially since we have a path forward. So I don't know if you want to clarify your points. I don't see that one of the options here is for me to call a pause and say, let's pick up next week. That doesn't seem to be on the table as I understand from Ms. Carroll. Ms. Carroll, is that accurate?
That is accurate.
Okay. Mr. Moore, do you have any follow-up based on that?
Well, I think that the veneer of an ultimatum seems to me, and perhaps to some of the rest of us, to be rather disingenuous in light of the disclosure of the attorney in question's participation in the proceeding last August. And I'm in the uncomfortable position, not as uncomfortable as probably the SSD council, but of having talked this through and had an understanding about it, and now being not entirely clear about what the potential consequences might be for the rest of the protestants with proceeding while the substance of the objection, while it's not going to be used for a remedy in this proceeding, is hanging out there. I guess I'll make one further attempt to see if we can get a clarification that people can live with that maybe would be helpful in making sure that this would not spill over to others. Perhaps there could be a clarification that any waiver by DWR would need to apply to any evidence developed by the SOMAC firm, but would not be a bar to other parties from using it in any other way.
So you're thinking about, Mr. Moore, the crossover of evidence developed in this proceeding being used in other.
Yeah, I mean, as I mentioned yesterday, I mean, as you know, we're in groups of protestants, and we all have tight time frames to meet as far as combined cross-examination and so forth. And if DWR truly wishes as well for the proceedings to go efficiently, the best way to do that is to have the protestants confer so that we can divide up efforts and have a clear sense, which we have developed on our own, of the appropriate order and division of argument. So here it appears that the show will go on, and matters introduced by the SSD firm on behalf of their clients will come up. And what I'm hoping for is just a clarification, if that happens, that it wouldn't, the fact that they brought it up or introduced evidence wouldn't be a bar to use the evidence or the arguments anywhere else.
I'm thinking this through because, I mean, part of this is, once again, this is what happens in other venues is outside of my wheelhouse, and I want to make sure I'm staying in my lane. Ms. Carroll, I don't know if you have a response to that.
I think I've been pretty clear on the record. I don't want to cause further confusion by responding.
Okay. Mr. Moore, I realize we didn't resolve.
I'm only referring to the matters that are within this proceeding, that are raised in this proceeding, and how other protestants can use them in this proceeding.
Oh, with respect,
that they may have other things to raise in other forums, which at the appropriate time, I guess we will raise in other forums if they come.
So you're asking with respect to evidence developed in this administrative proceeding that is then relied upon by the board, and which may, probably one way or another, may be litigated, and that with respect to this change petition that is pending before us.
Yeah, I don't think the DWR has really been transparent or clear yet about what the consequences might be for other protestants that might want to rely on that evidence or those arguments.
So maybe a point of clarification, Ms. Carroll, with respect to the waiver in pursuing a remedy to the objection, does that waiver extend to the use of evidence by other protestants as well as those protestants that are represented by the SOMAC firm in this proceeding?
I'm guessing I don't see how putting forth evidence related to the issues in this hearing are also related to the conflict issue, other than the matters are substantially related, but we aren't pursuing any remedy in this forum. So I'm not exactly sure how that affects any of the parties.
Me either. I think, Mr. Moore, did you,
I think
did you
I
want to
could,
follow?
Let me just ask this question, which I hope, and I appreciate you indulging me on this. The evidence that is introduced in this proceeding, whether by SSD or by others, would we still be able to use that evidence in other proceedings that are related to the Delta Conveyance project?
And that is a question that is outside, like I said, outside. That sounds like you're referring to proceedings that are not before me. But Ms. Carroll, do you want to respond to that?
Yeah, I think that is not a question appropriate for this forum, and we're not doing anything but waiving our own rights as to the remedy in this proceeding, and anything that arises out of this particular proceeding in appeal or litigation. It's very tailored to the impacts to DWR and this specific forum in order to keep the schedule.
Well, matters in this forum may be used elsewhere. And just as one example, the change petition, I'm assuming down the road may be part of a subsequent consistency certification by DWR. Would there be any problem with using the materials from this proceeding there?
If I might, Hearing Officer Kinsey, and
Sure,
this is
Ms.
really a
Blueberg.
point of clarification for Ms. Carroll, and just in terms of what the intent is. And again, we're just curious because there's a lot going on here, as whether if DWR was somehow in a hypothetical situation able to convince another forum that there was a conflict, which sounds like is potentially, sounds like a long shot to me, but I don't know the facts. Then could that potentially kind of taint, or in DWR's view, the evidence that would be developed in this hearing by the SOMAC firm and their clients? And I think that's where we're concerned about the record that's made here and its availability, and whether it is going to have a potential, what I would call like a shadow over it for those other proceedings. And I think that's the question that I have about the agreement that Ms. Carroll has offered. And then the second point I wanted to make, just be quiet after, is that Ms. Carroll has referred to the availability of a transcript. So I think this would be a wonderful time for DWR to commit to providing the transcripts to the hearing officer so that they may be included in this record and everyone can have that available to them. I would personally, and I know everybody would really appreciate that. Thank you.
Thank you. I think I'll go around the room, and then Ms. Carroll, we can turn back to you. Let's see, who have I said? Mr. Cho, please go ahead.
Thank you, Hearing Officer Kinsey. I have just two further points. Try not to belabor this, but that I would appreciate some clarification from DWR if possible. One has to do with this exploding offer that you described. Is that contingent on there being no delays at all for the rest of this hearing, regardless of their relation to this conflict issue? Or is it purely things that arise out of this conflict dispute that would trigger that exploding offer, so to speak, that would require us all to delve into this issue again? And I can make the other one.
Sure, let's do that.
Parties are going to have an opportunity to submit written objections to cases in chief and potentially other evidentiary items in this proceeding, with the objective to seek some remedy for lodging those objections. Is DWR stating that because it is waiving its right to seek remedies for any potential objections it may have, that it is also not planning to raise any objections that tie back to this supposed conflict?
I'll turn back to you, Ms. Carroll. I believe there were, well, do you have a response to either of those about just clarifying your understanding?
Thank you. Yeah, I mean, the intent of DWR is to keep this hearing on schedule. I think if there are reasonable reasons for delay that are unrelated to this conflict issue, we're not going to renege on our agreement to waive. As you've seen, we even asked for a slight delay this morning for one of our witnesses. I think that's completely reasonable. I can't speculate as to how other forums are going to treat the record or how they would rule on motions or what they would do in their forum. So I can't respond to Ms. Meserve. As to the transcripts, I still don't have them. I honestly don't. And so I cannot provide those. But once we do receive them, we are looking forward, as Ms. Kinsey or Hearing Officer Kinsey instructed us to, as how we can coordinate. So we're looking into that, but we don't have any of that. We're not implicating any other party's testimony, cross-examination. You know, this is purely with respect to DWR. So I'm not sure how to keep responding. I think we're clear as to we're waiving our remedy in this forum and that we're not waiving the conflict and we're not waiving in any other current pending litigation. It's just with respect to this proceeding and anything that arises out of the change of point of diversion proceeding that we would not pursue our remedies for conflict.
Thank you, Ms. Carroll. And I will add a point of clarification. My understanding is this is a waiver with prejudice with respect to this proceeding, in the sense that we're not going to keep revisiting this issue. I mean, there may be, I would expect there are going to be other bases that protestants ask for changes to the schedule, et cetera. And I would intend to rule on those based on the merits, certainly not, with respect to this claim. I want to put this, I also want to put this to rest once and for all. I realize there's this outstanding issue about the implications for other venues. So there are additional hands. I'd like to go through those and we can see if we need to continue the conversation. I think
real quickly, with respect, Ms. Kinsey, there was a second question that I had that I was wondering if DWR could respond to, and that was whether DWR has plans to nevertheless lodge written objections to any evidence generated by the SOMAC firm based on this potential or asserted conflict, even recognizing that it's waiving the remedies, but for whatever reason may seek to just paper the record with that. I think that's a valid question.
I believe the record is sufficiently papered.
Okay. Thank you. Ms. Desjardins, you've been very patient. Thank you.
Thank you, Deirdre Desjardins, California Water Research. So I am concerned that this exploding offer is fundamentally inconsistent with due process. It's not in writing. It's not being presented with sufficient time for counsel for other parties to consider it or confer with their clients. And it's also verbal. and there is no official agreement with DWR to get the transcripts and to make them part of the record. Furthermore, as a number of councils have made up, have asserted, it is an issue of prejudice to the other parties, that evidentiary parts of the record might be tainted for the consistency appeal. There was evidence from this hearing that was used in the water fix consistency appeal. And it is a significant burden on parties to try to develop evidence again. It's just a fundamental issue that this is a huge project. Part of the considerations are public interest. The DWR's own evidence refers to the Delta Stewardship Council consistency appeal.
So Ms. Desjardins,
it's not completely out of that.
I'm going to ask you the same question I asked Mr. Moore. What are you asking me to do?
I would like DWR to make you to request that DWR put this in writing.
I directed them to do that.
And that they submit it in time, and before it's approved, that people get a chance to review what's in writing, actually put in writing, as opposed to the verbal record where I think it's getting a little confused what's discussed, and we don't even know what's actually going to be in writing at this time. So I'd like it to be put in writing, everybody to confer, and people to agree, because that's just kind of fundamental, I think, to due process, that it be very clear what DWR is offering, and that all parties at least have a chance to raise the considerations with what's actually going to be submitted in writing, and then not be submitted at a future date, especially given that we don't even have a formal arrangement for the transcripts. Thank you. In the record.
Thank you. I will remind all the parties the official record of this proceeding is this audio video recording. That is always the case. The transcripts are a documentation of that. They are not the official record. The transcripts are for your convenience and for the court's convenience, of course. I think there are some who have been very patient. So can we please elevate Dan Kelly? And you can make your appearance once you're with us as a panelist. Good morning.
Good morning, Hearing Officer Kinsey. Thank you for the opportunity. I want to maybe caution everyone, including the hearing officer, about the consequences of what we're talking about. What DWR has alleged is a very serious allegation. And if they're right, I don't know if a conflict's even waivable. And if DWR is successful in pursuing a conflict action against the SOMAC firm, I don't know what that does to this proceeding. DWR has said that it's not going to pursue remedies. That doesn't mean that a remedy is not going to include the invalidation of any proceeding that the SOMAC firm was involved in. And so if it's that serious of a conflict as alleged by DWR, I think that the continued pursuance of this proceeding is going to leave a cloud over it, and potentially make it subject to invalidation if DWR is successful. So I mean, if DWR is really that serious about this, I think DWR needs to seek its remedies, and there needs to be a pause in this proceeding so that the rest of us that are spending significant time and money participating in this aren't going to run the risk that it's going to be invalidated at some future date.
Thank you, Mr. Kelly. So I think you were clear, but I want to make sure I understand. It's your understanding of the law, at least, I realize we haven't briefed the issue or anything like that, but your understanding of the law that a remedy that a court could impose, even if DWR didn't request it, would be an invalidation of whatever order the State Water Board may adopt out of this proceeding.
Yeah, I mean, I suspect that it's possible that if DWR in any proceeding alleges that the SOMAC firm has a non-waivable conflict, or they're not going to waive a conflict, then I don't know if any other if a court could invalidate this proceeding. DWR might say we're not going to pursue it, but a court might still invalidate it. Even if that didn't happen, having a ruling that one of the participating firms had a conflict and still participated in this proceeding, I think raises very serious questions about the legitimacy of whatever results from this proceeding. And that's just a very serious concern we have. We're spending a lot of time and a lot of money participating in this proceeding, and I don't want to have to redo it in the event that there's some future court decision or order that questions the validity of what happened here.
So from your perspective, the appropriate action for me to take would be to stay this proceeding before the AHO and the State Water Board, pending resolution of any objection by DWR presumably with the courts in these other venues.
I think that's right. I mean, DWR said that it's not waiving its objection. And so they have an objection in this proceeding to one of the law firms participating because of some alleged conflict. They haven't filed an action that I'm aware of to seek any kind of remedy in any proceeding because of some alleged conflict. And I think that needs to be cleared up. There's a pending objection. They say they're waiving a remedy, but they're not waiving the objection. And I think that leaves serious questions about the validity of this proceeding, should there be some later finding that there was a conflict.
Thank you, Mr. Kelly.
Yeah, and so I think, to answer your question maybe more directly, I think that is probably the appropriate way to proceed if DWR intends to pursue the disqualification of a law firm.
Thank you.
Thank you.
If we can, please elevate Ms. Safdie to panelist status. Good morning. And looks like you need to come off mute here.
Thank you, Officer Kinsey. I just wanted to take just a brief moment to just elevate a couple of the concerns that have been voiced that are concerns that I believe are held by my clients, the Delta and Tribal Environmental Coalition parties. A couple notes on this point. So just reiterating the last comments that are made, we appreciate the hearing officer's direction to put this in writing. Having certainty about what the nature of the waiver that is being proposed and its contours and what exactly it will embrace and how durable it will be in future proceedings that may follow from this one is really important. Of course, for all of us who are investing time and resources in these proceedings to know that they won't be affected by this in the future. Also because the City of Stockton and County of Sacramento and the public agencies that are represented by the SOMAC firm their interests are closely related to the interests that are held by clients like ours, who are members of environmental justice communities, which are situated in these geographies. And so having public representation by agencies whose interests are affected by this project is vital to the interests of those agencies, but also to the communities that they represent. And so we did want to elevate that and just note that the ability of these agencies to be able to proffer their testimony and for us to be able to draw from that and all parties to be able to make use of that as a durable part of the administrative record here is really vital. Another concern that I did want to voice was in understanding the desire to limit the scope of the waiver to this proceeding and subsequent appeals of this proceeding, is that this proceeding does have relationships to other proceedings that are before the board So that includes the time extension petition that's been filed and proceedings that may follow from that. And of course, also the related motion to dismiss that was filed with the State Water Board, which the SOMAC firm, their clients are also party to, which they joined in. And those are separate proceedings, but they're entangled with this one, and they do make use of the administrative record that's developed here will be relevant to those other proceedings. And so I wanted to raise that because making sure that the contours of the waiver, including with proceedings before the board that are closely related to this one, is going to be really important. And of course, the administrative record that's developed here may have relationships to other proceedings that may have relationships to this project, but are not direct appeals from this one. So I think that also just raises concerns about how durable the testimony is and the evidence that's produced here will be in other contexts in which our clients and others who are parties to this may seek to rely on it. And I think that's what we have to say. So I think from those vantages, I think having a clear and well-crafted waiver that we can all look at and assess its durability and possible ramifications for the parties that we represent in this proceeding is important. And then having a clear direction from the hearing officer, and that will be important as well.
A clear direction on what? Can you clarify that for
Sorry,
me?
on once if there's a waiver that's proposed waiver that's put down in writing, if there are concerns that are raised about the waiver, that the hearing officer does weigh in on that. The hearing office weighs in on that and resolves any questions that are outstanding. And I would also just reinforce as well that the last comment that was made that the testimony shouldn't be going forward until all of those questions are resolved.
Thank you, Ms. Safdie.
Thank you.
Mr. Moore, I believe we are back to you.
I just want to express my appreciation to Mr. Kelly and to Ms. Safdie for, I think, more succinctly and cogently getting across some of the points that I was trying to raise. I do want to honor the SOMAC firm's preference as how to handle the matter with their firm. But I do think that, for example, the potential complications that Mr. Kelly raised some things that merit consideration. And I, in seeking a pause for today, at least, and providing an opportunity, which we'll hope will be an efficient one, to address the issues that you just heard from Mr. Kelly and Ms. Safdie, would allay a whole lot of concerns that otherwise might potentially blow up and even slow down rather than speed up this proceeding through unintended consequences. This morning, we're in the position of, not even having a Zoom transcript to look through in the various phrases used that we can work through in any systematic way. And I think if this is worth working through and efficiently resolving, given the history so far in which DWR has requested a number of extensions on matters and been granted them, there should be nothing magical about having the rest of the cross-ex for today. There should at least be an opportunity to have I spent a lot of time with my clients last night trying to work through a coherent position, knowing that I probably couldn't reach them during the day. This would at least give us an orderly opportunity to review the rough transcript, look at what the issues are, and come to a clearer understanding that may have the positive consequence, not only of providing greater clarity, but avoiding pitfalls that actually may end up having this proceeding slow down rather than speed up.
Thank you, Mr. Moore. In thinking this through, so I think now it's time for me to turn back to you, Ms. Carroll, to make sure I understand what my choices are here, if you will. Does it remain the case that DWR's waiver, the offer of a waiver, is contingent on, I think we were going to have to take May 1st and 2nd off calendar anyway because of the availability of panel 3, or at least possibly, depending how far we got with panel 2 today. But does it remain the case that if we are not moving forward with panel 2 and Ms. Tabor's cross-examination today, that DWR would seek to maintain its objection to the representation by the SOMAC firm in this proceeding? I mean, what are my choices? I mean, they're my choices, but from DWR's perspective, I mean, you have control. It's your objection. So would it continue to stand, or what is the status of it?
I appreciate that, Hearing Officer Kinsey. The issue of the conflict is on notice in this proceeding. Whether or not that's an objection you feel like you have to rule on is up to you. DWR is waiving its right to any remedy in this proceeding, in any appeal or litigation that arises from this proceeding. It's absurd to think that DWR would want this hearing to go forward efficiently to just come back and invalidate the entire hearing. So I think it's understood that there should be no effect to the testimony or cross in this proceeding. The issues will be raised in other forums, which you've admitted and have stated that are outside of your wheelhouse, and for them to decide. I can't speculate as to what they will do. But as for this proceeding, we have a vested interest in it concluding and moving forward, and that is why we are willing to waive our remedy. We do understand that we were taking off May 1st and 2nd, although we may need to keep May 1st in light of the discussions today and the delay for the conclusion of the cross-examination, and we are willing to do that. If people do need more time and you determine that, I do think that taking the rest of today would be appropriate. And I just wanted to go on to say that, yes, while there are other matters before the State Water Board that are related, and it's based on the same project, they're not so entangled that they can't be separated. There's no reason that we are required to rely on the record built here in those proceedings. We do not have a hearing scheduled for time extension yet.
Thank you. I'm thinking, obviously, this is a long pause about how to resolve this efficiently, given the variety of positions here. I mean, I think one path forward is to get the waiver from DWR in writing, although I don't think that the words will be the same. So I'm not sure, and the outstanding questions will be the same. I think we've daylighted a number of questions. So I'm not sure that will, I think the concerns raised by the protestants about the impact on evidence developed in this proceeding and how it could be used in other proceedings would still stand. What I've been trying to elicit from the protestants is whether, and at least Mr. Kelly was very clear that the request would be to stay this proceeding while DWR addresses the conflict objection, which I would hope would happen in a different forum from here. I'd rather not go first on that. And I'm not sure that I have, we'd have to look at the issue of whether I even have the authority to remedy the issue. It may be that it would be beneficial for all of us to think about it and come back. So I'm going to look to the room for proposals. My inclination would be to break for today, but to come back possibly not in person, but in writing on Monday or Tuesday, so that when we reconvene on May 1st, which I would plan to keep on calendar, that we would have some additional information. I'm trying to think through what we would develop in the meantime. You would have the written statement from DWR, although I think that will not, as I mentioned, will not add clarity in addition to what we've already heard today. That said, all of you will have a chance to talk to your clients and confer with one another and confer with DWR with respect to whether there's a possibility of tailoring an appropriate waiver so that we can move forward with this proceeding. On the other hand, it's so complicated, I'm not sure. But maybe we've lost nothing in that. Given the opportunity, and if the other option is to stay this proceeding pending something else, some movement with this issue in another forum. Ms. Meserve, please.
Thank you, Hearing Officer Kinsey. Just a couple of brief comments. Number one, I think Ms. Sofke was wise in bringing up the other proceedings before the state board. I think I think the hearing officer is aware that it's DWR's position that those proceedings can be separated from this proceeding. Other protestants disagree and have alleged vociferously that in particular, the time extension, is not separate from the considerations in this hearing. So I just want to be clear that that's a position of DWR, that it is separate. Secondly, Mr. Kelly, articulated, I think, the reasonable approach given all these concerns, which would be to stay the proceeding unless and until DWR waives the objection entirely, because otherwise we all bear the risk of having this infect, whether it's this proceeding, other proceedings before the board that are related, and then in addition, these other proceedings outside of the board that are also related. And I would just say, I take Ms. Carroll at her word that she wants to get through this and that they are, trying to expeditiously resolve this. However, I would caution that many of us here in this hearing also went through 3 years of the water fix hearings. And our clients put in, all the time and effort, and many of them nonprofits or, public agencies as well, in order to try to put forth evidence and, and that proceeding. So, the resources of the state are vast, and, the state can change its position, and the state is more able to pick up and do it all again than, the folks who are most impacted by this project, that many of us, that we here in the hearing represent. So there's some very, I think, important public interest issues in having a clear record and making sure that, the time we spend here is, is not subject to some sort of cloud over title. Thank you.
Thank you, Ms. Meserve, and I understand. Thank you for your points. I am amused when you say the resources of the state are vast. My resources are not vast, but that's neither here nor there. It made me think of when I was prohibited from ordering pencils for a period of time, but we now have pencils. You'll be happy to know. Mr. Ferguson, please. You're on mute, it looks like.
Based on what we've heard today in terms of the verbal waiver, and we're not going to stand in the way, and we're prepared to move forward with cross-examination. But if you're going to direct them to present something in writing, then so be it. But again, we're not going to stand in the way based on what we've heard today.
Thank you, Mr. Ferguson. Mr. Cho.
Thank you. Not to undermine Mr. Ferguson's comment there, I just wanted to note for the record that I would join in Mr. Kelly's comments that if DWR does believe that there is a substantial disqualifying conflict that needs to be addressed, that it should act immediately to do that so that that issue can be resolved and there's not a cloud remaining over this proceeding and others.
Thank you, Mr. Cho. Ms. Desjardins.
I just also want to join in Mr. Kelly's comments. Thank you.
Thank you. So I think the thing for me to do is I would like to take a break so I can think about this. It at least merits that off the, well, I'm not on Zoom camera. We can think about time. I would like to come back this afternoon and reconvene, but Ms. Carroll, please.
Yes, just while you're on your break and you're considering, two questions I had were, how does this discussion today affect our clocks for time moving forward? And then also, we would like to return on May 1st. We do think we can reach an appropriate resolution, especially with Mr. Ferguson's assertion that they are willing to move forward. We'd like the hearing to continue to proceed. So I just wanted to make that request.
Thank you. Let's go ahead. I think what we should do, and this may benefit all of us, let's go ahead and take a break. We'll wrap in our lunch break as part of this, but I'd like to reconvene. Shall we reconvene at 12:30? I know it's a bit of an early lunch, but reconvene at 12:30. That gives me a chance to think about it, all of you a chance to think about it. We'll see if anything, and I encourage you to, I know it's not a lot of time, but thinking this through and coming up with an appropriate solution, I think we all that will allow this proceeding to proceed unclouded, if you will. That is a concern, and I do, although I'm within my wheelhouse and my lane, the point about other state water board proceedings is important because there aren't very many hearing officers at the AHO, so this may be squarely on my plate in the next proceeding, and I would prefer to resolve it one way or the other. So please do think about it. Think constructively. What is the plan to move forward? What would be an appropriate plan to move forward, given the positions that have been articulated this morning? And let's go ahead and reconvene at 12:30, and we will pick up this discussion. Thank you very much. Hello and welcome back. I will look first to see if we have our court reporter. Are you ready for us to go back on the record?
Yes, Hearing Officer Kinsey, I'm ready.
Thank you. I'm sorry, I was just things are happening fast. So where we broke off was about an hour and a half ago, a little less, was with respect to this issue about the potential conflict. I thought first what I can do is let all of you know where I am at after having thought about this over the lunch break, and then seek any input. Hopefully all of you have had thoughts or discussions over that break. As you know, I'm in this interesting position where it looks like the new development as of today is that DWR is willing to waive any remedy in this proceeding based on their objection. And I believe DWR submitted a written statement over the break. I just saw that, so that's the best articulation of their waiver or offer of a waiver. And the parties represented by the SOMAC firm are willing to move forward. And then we had a long discussion with other protestants raising concerns about what that means not only for this proceeding with respect to other proceedings before the State Water Board, and then with respect to judicial proceedings that may be pending now or in the future. I think based on that discussion, what the issues that formulated for me over in thinking this through is one, and what I'm considering is whether we should have some kind of written, I guess you could call it briefing, but something like this. But here are the questions that have come to mind. One is whether third parties have essentially standing to raise an objection based on a alleged conflict of interest if that party is not implicated in the conflict of interest. For example, I mean, and I think here mostly comes to mind state water contractors and others who may support DWR's position, whether such a waiver would include any objections raised by those parties if they have standing to raise these objections. And then the other piece of this, I think, that was raised by the protesting parties is not raised by the protestant, but by their position for me, is whether, although a party may be burdened by the circumstance in which we move forward with a proceeding, there's a later determination by a court that there was a conflict of interest, which puts a cloud over the validity of the evidence. My question is whether, although it may be a burden of some kind, is there any legal right involved? I mean, I think we go forward with these proceedings and there's often some kind of cloud, right? That we can't proceed with all of our litigation linearly or administrative proceedings linearly. There's often a question in a simultaneous proceeding, whether or not, the outcome of that simultaneous proceeding or whether that will affect another decision or the validity of another decision. I think as lawyers, we deal with that a lot. What I see as a distinction here is that, at least from my review of the case law, which is not, it's been over the last couple of days, but my understanding is that courts have allowed interlocutory appeals, and interlocutory appeals, I don't want to say it's a good idea, but those are allowed in situations where you have an alleged conflict in recognition of the fact that those types of issues need to be resolved before you go forward. You don't get to it doesn't make sense to get to the end of a trial and then deal with this question of an alleged conflict. But I'm not sure that standing with respect to that type of issue extends to anyone other than the parties involved, in this case, DWR and the SOMAC firm. And if a court wouldn't recognize an interlocutory appeal in this situation, I'm not sure it makes sense for us to stay this proceeding and wait for a court, given that I don't know how long it would take, but it seems like it could potentially take a long time. I'm very concerned that to leave an open-ended stay based on a resolution of the issue would possibly be at least months, if not years. And that concerns me very much. So I'm weighing these different factors, and I think some better understanding of the law on these issues of third-party standing, as well as whether any third parties have any legal interest in the resolution of these types of issues, would help me to come to a more informed decision about how we move forward, given that there is a waiver on the table. And as far as I know, it's remaining on the table. So that was not a scripted, I thought it through, but that was clearly not from a script. So I apologize that that didn't come through as eloquently as some of you who had formulated your thoughts in advance this morning. But with those thoughts, maybe I'll turn, Ms. Carroll, I don't know if you have anything to add to the discussion based on where we are so far.
I don't believe I have anything to add at this time, just would also reiterate that we share the same concern about delay.
Thank you. We can please, well, Mr. Ferguson, you don't have your hand up, but I'll turn to you first, or Ms. Tabor, if you have anything you'd like to add at this time.
I do not.
Okay, thank you. That's fair enough. I thought I would ask before I moved to the room. And I should say, to have a more informed discussion or more focused discussion, what I'm considering is putting these thoughts and questions in writing so that all of you, so you don't have to go back to some Zoom transcript and try to understand what I meant, and do it very quickly this afternoon or by tomorrow morning, and then ask for short briefing on the issue. We could say either the end of the day Monday or early first thing Tuesday morning, and then we would reconvene on May 1st and make a decision at that point as to next steps. I think the result of that briefing could be quite informative, where we would have some clarity on who has standing to raise these issues. I realize I had said we would resolve this issue today. I think the offer of a waiver was a new one. I didn't see that coming. So I recognize that we had said we'd resolve it, and now we are not, unless you tell me otherwise. So with that, I will look to, I see I have Mr. Keeling. I think you had your hand up earlier. So Mr. Keeling, you're welcome to jump in if you would like. You do have to come off mute though for us to.
Thank you. Thank you, Hearing Officer Kinsey. I've gone from being promoted to elevator to unmuted to now I'm being welcomed. I really appreciate that. And by the way, I understand that this must be the hardest job of in any administrative proceeding in the state right now, maybe in the history. So I appreciate that. And I know that this is an unwelcome bump in the road for you. I do not know if you have the authority or the power to resolve this issue, but I do believe you have the power to deem it waived, meaning the objection or the supposed conflict. If DWR elects not to pursue this issue, and I mean now, I think that you should rule that the objection has been waived. This is a Rube Goldberg proposition that's been put before us by DWR, this idea of waiving the objection for this proceeding only, and or not waiving the objection, but waiving the remedy in this proceeding only without resolving it. It's a serious problem. It won't cut it, and it casts a shadow over not only this proceeding, but all the related proceedings. And by that, I mean, for example, the CEQA action, in which, gosh, in large part through the hard work and talent of the SOMAC firm, the parties on our side of the table have secured a preliminary injunction, successfully defended it against a motion to stay the injunction, successfully defended it against a petition for writ of supersedious when DWR went on appeal, and successfully defended it against yet another motion for stay. The SOMAC firm was at the center of that. The SOMAC firm was at the center of the validation action, in which we, on our side of the table, obtained a judgment. DWR is up at the Court of Appeal on that, and so on. So the SOMAC firm has been at the center of every major battle. I can see why DWR is searching desperately to get them out, and that this latest contrivance is the rather insulting way in which they've come up with doing it. On the point of using evidence developed in this proceeding, I'd point out that evidence developed in part by the SOMAC firm in the water fix proceeding was used by me and by our clients, among others, in related proceedings, such as the DSC proceeding in 2018, which concluded successfully for us, and in the CEQA, in various CEQA contexts. And in that respect, I want to put DWR on notice today, April 24, 2025, that my clients, which include, of course, in this case, the County of San Joaquin, but in other cases, San Joaquin, Solano, Contra Costa, Yolo, and various water agencies, we want to put DWR on notice that we fully 100% intend to use evidence developed in this proceeding in part or in full by the SOMAC firm in our related cases. That would be the CEQA case, anticipated DSC proceeding, so there can be no charge later that they were surprised. If they want to do something about this, if they want to get off, if they want to put up or shut up, they better do it now. And I really believe that this device that they've come up with is jury-rigged and is going to cast a shadow. And really, Ms. Kinsey, I think you should deem this objection waived. Thank you.
Thank you, Mr. Keeling. If you can humor me, and this may be a subject, for briefing, you could add this to your briefing if we go forward in that way. If I deem it waived, first of all, maybe you can articulate to me what you're envisioning the basis would be. I'm not saying that there's no basis, but just to better articulate that for me. And then articulate for me why you think, or if you don't, why that would be binding in any other proceeding or in court, or maybe that's not what you're thinking. I'm not sure how this helps you if I deem it waived.
Okay, if you deem it waived, you've uncast the shadow in this proceeding. If they want to assert this in some other proceeding, be my guest, let them do it. But this is confusing the issue. It has to be a clean slate here. This idea that we're going to maintain our objection, but we're going to waive the remedy here is nonsense.
Thank you. And then what would be the basis to deem it waived? The time delay in raising the issue, or the offer? What would it be?
If they're not willing to pursue it in front of you, and I'm not sure you have the authority to decide it, by the way. I haven't researched that. You've researched that. I haven't. But assuming for a moment that you do, that their inability or unwillingness to go forward and establish a case of conflict should be a basis for deeming it waived. And if you do not have the authority, if you conclude you do not have the authority, then I think this proceeding needs to be paused so that some decision maker with authority can decide that issue. Have I answered your question?
I think so, yes. Thank you, Mr. Keeling. And yeah, I have thought about the issue, but I'll be completely transparent to all of you. With respect to the degree of my authority on this issue, I have come to no conclusion whatsoever, not even not even close. So that is very much something in my mind. Hopefully we won't get to that point. Ms. Desjardins, I see your hand is up.
Thank you, Ms. Kinsey. I did want to say that I thought about the next this issue over the break and did some research, and the issue is that the evidence before the water board, there is a nexus with the Delta Plan consistency determination, and that a number of exhibits cite the Delta consistency with the Delta Plan. Particularly, for example, I did a long cross-examination, which you sat through, of Glenn Buchholz on the DCA memo on the intake application, and that extensively cites consistency with the Delta plan. So the question is, if the water board's going to rely on evidence like that, that refers to consistency with the Delta plan, but there's an issue before the water board that could lead DWR to request to exclude this entire record from that proceeding, it really creates an issue. So I do think there's a nexus. It seems kind of difficult to research, but there definitely is in the evidence that DWR submitted with the consistency hearing in the Delta plan. Thank you.
Thank you. Yes, and certainly noted that there is a lot of overlap between these issues. I mean, the consistency determination, frankly, when I was thinking over the break, there's at some point, presumably, there would be a 401 certification issue before the State Water Board that's directly on point. I mean, there are many other overlapping proceedings, both before the board, other agencies, and the courts. Mr. Donlin, please.
Good afternoon, Ms. Kinsey. Can you hear me okay?
Yes, I can. Thank you.
Great. We agree with your approach to require additional briefing on these issues. We also agree with some of the concerns that Mr. Keeling just raised. With respect to the briefing, though, we would suggest that maybe there's a few other issues that DWR could brief as well. Specifically, whether the conflict is waivable, whether it's proper to waive the remedy to a conflict without waiving the conflict itself, whether the waiver is consistent with the rules of professional conduct, specifically Section 1.9. And we also share your concern about the standing of other parties to assert a conflict, even if DWR doesn't. So with that, we would ask that the briefing include those issues and perhaps a little bit more time than you've allotted to resume the hearing on May 1st.
Thank you, Mr. Donlin. Thank you for that. That was constructive, certainly. Ms. Carroll, will go to you, and then I see there's some others with the hand raised. So Ms. Carroll, though.
I don't want to disrupt the flow here, but I would like to ask a courtesy that we be allowed to release our witnesses, as I don't believe they'll be testifying today.
That seems fair. Yes, absolutely. Thank you.
Thank you.
If we can please elevate to panelist Mr. Rees and Mr. Cho as well, at the same time. Good afternoon, Mr. Rees.
Good afternoon, Officer Kinsey.
Or Mr. Herrick, I'm not sure who to expect.
Well,
Okay.
yeah, it's me. I've listened carefully, and Dean Rees on behalf of the SDWA parties, and I'm still somewhat confused, which I think indicates that the comments from Mr. Keeling and Mr. Donlin and what you began to articulate earlier this afternoon or just a few minutes ago, that there needs to be briefing on these issues and enough time to brief it adequately is, I think, the only appropriate approach to take at this point. So we join in the support of briefing and with the added issues that Mr. Donlin articulated.
Thank you. And Mr. Cho.
Thank you, Hearing Officer Kinsey. I just had one additional comment. And this has been implied in the earlier commentary about DWR's notice of Ms. Shorrock's participation in the hearing. But since you and Ms. Carroll both reiterated concerns about undue delays that might be associated with getting some finality on this potential conflict issue, which I am sympathetic to, and I want to see this hearing move forward, I just think it needs to be explicitly recognized that all delay and interruption in this proceeding as a result of this conflict issue is the direct product of DWR's failure to act on it before the hearing began. That's all I wanted to say.
Noted. Thank you, Mr. Cho.
not undue if it has to be done, right?
Mr. Ferguson.
Schedule is not more important than making sure.
Yeah, I just want to be clear on what our understanding is and what I think your interpretation, Ms. Kinsey, is of what DWR is proposing. I heard you earlier state that DWR appears to be essentially waiving its right to raise this issue again, which means it's prejudiced from doing so again in the future and within this proceeding and on any appeal. And I don't know that that needs additional briefing. And in our view, it seems like they've got the ability to waive that right. It's on the record. If it comes up again, I assume you would revisit this, the transcript of this day and say, DWR, you waive that right. This is not the appropriate time to bring it up again, and we'd move on. So I guess I have a bit of a concern that folks are almost asking for an advisory opinion from you without really needing to, and without maybe a set of concrete facts that would form the basis of any opinion you would ultimately issue. So that's the concern I have about the briefing and carrying on in that direction. And I would just want to make sure I do state that SSD and its clients' agreement not to stand in the way of the proceeding moving forward today based on DWR's waiver. In doing so, SSD and its clients are not waiving any claim or defense or argument or assertion that SSD or its clients might make in other forums to the extent DWR attempts to raise this issue. So I just wanted to be sure that that was clear on the record today.
Thank you. Thank you, Mr. Ferguson. Ms. Carroll, do you have any input that you want to make on the question of briefing and the timing of that briefing?
I agree with Mr. Ferguson that I don't believe that it's necessary. I think we've made our waiver on the record. We've put it forth in writing per your request. There's a question as to authority, and I think it's going to further delay the proceeding without actually reaching a conclusion that we'd all be happy with. I don't know if all of these parties could reach a compromise or a resolution on this, and that really the only thing is to move forward.
So I'll look, I don't see any additional hands. My inclination, as I think based on this additional conversation, is to go forward with some limited briefing. What I would consider is that the DWR and the SOMAC firm, I wouldn't impose page limits. On others, it would be 5 pages. I mean, there are many of you. That it would be due 8 a.m. on Tuesday morning. Hopefully you wouldn't be working all night, but just to give you more time. And then I would want to come back if it reserve May 1st for convening with all of you once again based on that information. And again, I would articulate these questions more clearly in writing so that you can have them in front of you. But really looking for you to educate me on the case law related to these issues. This is, I'm a lawyer. I'm familiar with lots of things, but I'm mostly a water lawyer. And particularly where there may be limitations on staying in my lane, if you will, and how to navigate this process in a way that's sensible. Ms. Meserve, please.
Thank you, Hearing Officer Kinsey. Yeah, with the direction from you as to what to brief, that makes sense to me. I guess my concern is, we have a lot of hearing days. We've been very busy this week. I personally have, another big brief in another matter due Monday. That's going to take my entire weekend and Monday. So I guess, I kind of this whole issue could be gone if DWR would drop it, which it doesn't appear that it has evidence adequate to put forward in this hearing regarding the alleged conflict. And so, I think burdening us with a very quick briefing based on some kind of emergency created by DWR's own actions and delay in bringing this forward, if it was a big concern, I think we would need more time. And then I would also point out that we protestants are working on our cases in chief, which are due on July 11th. And all of this is, I know, none of us have that, additional capacity to take on, this issue, which I think, and I think we need to address the issue of standing and things like that. And there is, I think, an interest, among the other protestants that goes beyond the SOMAC firm because of the other proceedings that have been mentioned. So I guess I would just respectfully ask for a little more time. And then also that depending on how much more time this issue takes out of the orderly proceeding, then I would ask too that, we may need, a slight delay in the case in chief deadline as well. Thank you.
Thank you, Ms. Meserve. Ms. Carroll, please.
I have to say that request is completely out of line, given that they have an additional 3 months to do their case in chief, and that I believe the deadline that you've set is completely adequate for the questions that you asked. I would object to the inclusion of the requests for us to do additional briefing on waiver. If DWR had the luxury of time, or if the importance of this project were not such that we could not delay, and if we thought that there was actual authority and this was the appropriate forum, we'd be vigorously defending this here. However, based on the importance of this project and based on the need to move forward, we are offering a proposal to streamline these proceedings so that they can continue and that we can take this up in a different forum. So I just want to make sure that that's absolutely clear.
Thank you, Ms. Carroll. And I did want to turn back, if I could, to Ms. Meserve, just to clarify one question. I think you mentioned that, because I keep kind of going round and round on this, that if DWR were to drop, I think you said drop it, that's what I wrote down, but drop, I assume the objection, or maybe you can articulate what you mean and what you mean by drop it. Do you mean with respect to this proceeding, with respect to all proceedings? What would be, in your view, a satisfactory outcome from DWR?
Well, I mean, I think, again, we're all kind of dealing with this in real time, but I think at least with respect to waiving the conflict completely as to this proceeding would be necessary, right? Not just the right to seek a remedy, this very limited approach. And then in addition, yeah, I mean, does that answer your question?
That does. Thank you very much. And Mr. Reese, please. If we can please, I think Mr. Reese is no longer on the panelist. He needs, if we can re-promote him.
I guess I kind of lost my thought as I was talking to you. If I could just chime in while we get Mr. Reese back. But I mean, I think the big concern that I have, as I mentioned, is whether somehow these other if there was other proceedings regarding the conflict in a different jurisdiction, then if the outcome or the evidence in this proceeding could be tainted such that it couldn't be used, or even that the outcome, as Mr. Kelly pointed out. So, that's a risk on all of us that DWR is asking the protestants to take on the burden of. Now, DWR may be comfortable with that because if that happens, which again, may be unlikely, then, it will say, oh, well, we didn't ask for, for that proceeding to be set aside, or we didn't ask for, the evidence to not be usable in a different proceeding, such as the consistency. So, and then I think one other thing is, there's also, you mentioned the 401, Water Board itself is acting as a responsible agency under CEQA. So there is a connection between the other litigation on CEQA and other matters, and the Water Board back to it. So, this is all very intertwined. And I think that's why, we're looking for some kind of clear resolution that removes the prejudice that, may not be, I mean, right now, all we've been prejudiced by is spending time talking about this, but there's a lot more prejudice out there for our clients. And, I think that's why all of us are saying, we want to resolve it rather than sweep it under the rug.
Thank you, Ms. Meserve. You helped me to articulate or clarify in my mind one possibility. And Ms. Carroll, you may not have I know you're on the spot, you may not have an answer, but it sounds like there's a question as to whether DWR would be willing to waive any remedy with respect to this proceeding and any objection to evidence developed in this proceeding as it may be used in any other proceeding. I mean, if that's an additional piece. And I don't know if you had any comment on that, Ms. Carroll, as to whether or not that was intended to be included or excluded from what you had on the table. So, for example, let's make an example. If Ms. Tabor were to engage in examination of our panel 2 witnesses, and that testimony is then included in the evidentiary record for this proceeding, and a party sought to use that testimony and rely on it in proceeding on the consistency determination with the Delta plan, does DWR is your intent to retain your right to raise an objection to that evidence in the parallel proceeding?
I'd have to take that question back. I don't think I have authority to answer right now, but I'm happy to look into it.
Understood. Thank you. And that was, that seems fair. Mr. Kelly, please.
Yeah, thank you. I know that Mr. Ruiz came back online, and I don't want to step in front of
I'm sorry.
Mr. Herrick, so I will stand down.
It's if you leave, and maybe the hand raise probably comes down when you're promoted to panelist. I realize I've done this several times where I forget where I am in the queue, and I apologize. Mr. Rees or Mr. Herrick?
Thank you. This is John Herrick, South Delta Parties. I just have to comment here. The interest of the governor or DWR or the state board members or anybody in making this proceeding move fast is irrelevant. We're in the middle of a petition that's being conducted before an administrative law judge, and it either goes slow or fast. We can try to move things along, but the avoiding resolving things because we want to move forward, I think, is a grave mistake. The initial threshold question is, does the administrative law judge or hearing officer have the authority to make a ruling on this? Until we've decided that, everything else is irrelevant. And once we decide that determines whether or not it's recommended that we should go forward or not go forward. So this thing has to be briefed, and nobody who's on this virtual meeting or listening to this, none of us know the potential consequences of DWR waiving a remedy in this proceeding and how it affects other proceedings, which we know are either going on or will go on that deal with this very topic. Now, maybe slightly related things and not the exact issues, but it's the same topic. And I just, if the proceedings aren't, stayed until we resolve this, whether you have authority and whether you can rule on this and what you would rule, it's a horrible morass of problems if we proceed. And so I would recommend, as I think we've already said, we have to take a time out from the hearings and then resolve these issues. DWR's not going to give up its rights to go after its desire to get the tunnel built. That's fine. But waiving a remedy in one of many proceedings sounds like a ploy to me, not a resolution. We're not here to all reach agreement. We're here to have a ruling, and somebody wins and somebody loses. We're not trying to split the baby in half. We're trying to, each side is trying to prevail. So with that said, again, the proceedings need to be stayed until we decide whether you have the authority to make a ruling and then what that ruling might be. There's no working this out. Thank you. I apologize for not having my coat on because I wasn't going to appear today.
Thank you. Thank you, Mr. Herrick. Mr. Kelly, please, I think now to you.
Yeah, I appreciate that. And I just want to note that I think that the question, hearing officer, that you just posed to DWR and their inability to answer that question directly really sort of exemplifies the morass that we're in with all of this. The inability of them to say, sure, people can use evidence developed here in other proceedings, demonstrates the prejudice that Protestants are suffering because of this conflict. I'm also curious, I mean, if this is that important, whether or not DWR is actually seeking a remedy. There certainly is an opportunity to apply for a restraining order or an injunction over this conflict issue prior to the conclusion of this proceeding that would clear it up. And so it would seem that in order to make sure we preserve the integrity of this proceeding, that if DWR is going to move forward, they should have to move forward and resolve this instead of concluding this proceeding with that cloud hanging over it. Thank you.
Thank you, Mr. Kelly. And holding just a moment, I think you articulated well one of my questions. You mentioned the risk of prejudice to Protestants with respect to the use of evidence. And I think that's exactly one of the issues I was asking about, and you probably picked up on that. Is it prejudicial? Is it more than, I mean, it can be inconvenient, but does it rise to the level of prejudice? And that would be one of the things I would be interested in hearing more about.
Yeah, I mean, I suspect that, and this would be incredibly inefficient, but if the concern was that testimony that the SOMAC firm was able to elicit from witnesses might not be available for the rest of the Protestants in a future proceeding, then the rest of the Protestants are going to have to elicit that same evidence in order to protect the ability to use it. That seems like an incredibly inefficient use of time. And so, that's an option, but it just seems inefficient.
Thank you, Mr. Kelly. I believe next was Ms. Desjardins.
Yeah, I did want to call attention. Ms. Carroll did say the parties to this proceeding are on notice that DWR believes that there's a conflict with SOMAC, Simmons, and Dunn that prejudices DWR and only DWR. And I really question that, given that Ms. Carroll can't answer about evidence that I developed in cross-examination and whether it would not be available in other proceedings. That's a very real question, and to say that it doesn't prejudice me or similar cases for other Protestants doesn't prejudice them about it. I don't think that issue of whether it prejudices other parties, the evidentiary issues, should just be asserted by DWR, and particularly not with an exploding offer. I understand the wish to move forward, but as I join in Mr. Kelly's concern, the integrity of this proceeding needs to be maintained. And it isn't maintained just through assertions by DWR's counsel. Thank you.
Thank you, Ms. Desjardins. I think that once again, you're reiterating the basis for my questions, which, as Ms. Carroll pointed out, the duty of loyalty of an attorney is to their client or former client. And then my question is there any other legal obligation that is, or legal standing that's at issue here and the potential for prejudice? So I think we're teeing that up as an important, obviously, it's an important issue. I didn't see you. I think, Mr. Ferguson, you were next.
Yeah, I can appreciate the interest that a number of parties have in briefing on questions of jurisdiction and use of evidence in this proceedings and other proceedings. But it's unclear to me what request is on the table of you that this briefing would help inform. And so it doesn't seem to me that there's a request on the table for you to make a specific decision that this briefing would help inform. So I guess I'm not seeing at this point the need for that briefing.
Thank you, Mr. Ferguson. I think it's a good point because I keep asking that of all of you. Here's what I see, and we can talk about this. I think the connection is here, which is if I am being asked to stay this proceeding for an indefinite period of time pending resolution of this question in another forum, I do think the legal standing of the parties who are claiming prejudice may be relevant, given that there seems to be an agreement right between DWR and the SOMAC. I don't want to say agreement, I don't want to overstate it, but there is a path forward with this proceeding, but the protestants have raised other concerns. So one question is, should I stay these proceedings on that basis, that the protestants have a legal interest at stake, and for that reason we should stay these proceedings, even though your clients and DWR are prepared to proceed. The other piece of this, and hopefully I didn't lose my train of thought here, is I think a question of whether I have authority to, I mean, I guess I don't need to accept the waiver from DWR. That's up to them. So maybe that's right. I mean, is that your point, Mr. Ferguson, that there's no action on my part in terms of accepting a waiver, or I'm not confirming anything with respect to an agreement and a waiver that is between, well, it's DWR's choice. I think it's, as you pointed out, it's just DWR who is consenting to the waiver.
I agree. I don't see what there is to for you to act on with respect to DWR's waiver.
Understood. So then the question, I think, remains, which is, should I stay these proceedings at the request of the protestants while this issue is resolved because of a claimed legal interest by the protestants?
Okay, thanks for articulating that.
I think. And then another piece here, I think, though, also is the position of state water contractors and others. I think the companion question is whether they have standing to raise these objections, which then could, in spite of DWR's waiver of a remedy, they haven't waived a remedy, and do they have standing to raise them later, which may also interrupt these proceedings. Ms. Meserve, I believe you're next.
Thank you, Hearing Officer Kinsey. Just one thing that I thought would be helpful as well is, I mean, this discussion, I think, has to do most of all with the orderly proceeding of the hearing, perhaps, without waiving any right to standing I might assert later on behalf of my clients. I think what I'm most concerned about right now, without having had an opportunity to research the issues you mentioned, is the orderly proceeding, and that it's not just the cross-examination, for instance, that someone from SOMAC may conduct, and it's also how the protestants are developing their cases in chief, and which protestants are developing which materials for cases in chief. And we are in the process and have made decisions about which evidence we need to put forward, in part based on what other protestants are putting forward, so that in order to be efficient with resources in this major proceeding that is a huge burden on the local governments and communities where this project is proposed. So if I have to decide or work with my clients to figure out, if I thought, oh, well, there's going to be case in chief testimony developed with an expert that may be in danger potentially, hypothetically, of being, attacked and not being able to be used in a separate proceeding, which, Ms. Carroll said she would consider and maybe get back to us, that's a very real impact on the planning that we're doing around our case in chief testimony. So, there's certain I think I have made the assumption that all of the evidence that is properly accepted by the hearing officer into this proceeding will be part of the record. If that's in question, then that, gets back to this whole issue of inefficiency that I think Mr. Herrick articulated quite well, and why there's a need to have certainty around the fact that there's not evidence that's going to be subject to attack on a specific issue that's been raised and not fully waived by DWR. Thanks.
So, Ms. Meserve, thank you for that. Let me follow up on this to help my thinking. Why is it that you and the other protestants should have the opportunity to develop evidence in this proceeding that's not intended to be used for the State Water Board's decision, but is intended to be used in a different proceeding in a different forum? I guess I'm puzzled by this, right?
I'm sorry, that's not what I was talking about. I'm talking about decisions about what we're going to put forth in our evidence in the case in chief. For instance,
but DWR has waived any remedy. So anything that's developed, all of the evidence that properly comes in is going to come in and be relied upon by the state board. So why is that a concern to you if it's all in the record?
Because because there's decisions being made about who needs to put forth what evidence. And if I thought, for instance, that SOMAC and its clients were working on with a certain expert, say, to put forth evidence on a topic, then, perhaps I would not, put forth that evidence. But if that evidence could end up not being, attacked, if it would end up being, yeah. So you're right. It's more a concern about other proceedings, but it also seems like it could affect other related water board proceedings as well. So I think, we all need to think about it more clearly, but I guess I'm just concerned that it creates a whole additional burden on the protestants to make sure they've covered the water more broadly, because we want to make sure that every issue is covered, and that sometimes evidence developed in these proceedings is relevant to other proceedings. And if we're not allowed to rely on the fact that it's, not subject to attack in those other proceedings, that I think it affects some of the choices that we would need to make.
Thank you, Ms. Meserve. Let me reflect back. I think just to ground this, I think in the example I gave with the consistency determination, that a concern is that instead of being able to use evidence developed in this proceeding, you would have to separately develop that evidence in that proceeding. Is that a fair characterization?
Well, I think we can't assume that everything from this proceeding would be not subject to attack in a different proceeding.
Right. And so therefore you may have to develop it separately in that proceeding.
Correct.
And then that is where I'm interested, because and you're right, there are other state water board things, but in some ways that's not directly my concern, although it may be if this is a state, if it's an AHO, we may be talking about a future AHO proceeding. I realize that as well.
Yeah, I guess more than anything, it just creates uncertainty about what the record would be of this proceeding that is, complete and usable as it is, as a complete record. So usually after the AHO makes rulings on evidence, that's kind of the end of it. But it just seems like with Ms. Carroll's answer, she's not committing one way or the other about, whether some kind of objection might be raised in a different proceeding based on this same allegation of a conflict and the source of the evidence. So it just I think it creates a bunch of uncertainty where there shouldn't be any.
Thank you. Thank you, Ms. Meserve, and thank you for working through that exchange with me. That was helpful. I believe you're next, Mr. Krieger.
Thanks, Hearing Officer Kenzie. You had questioned about the standing, for example, the state water contractors, and I just want to be clear for the record that state water contractors have not made any motion. And sitting here today, I can't tell you that we even have standing to do so. And particularly, I don't understand SOMAC, Simmons, and Dunn to be asking for a waiver from the state water contractors. So I think, to borrow Mr. Ferguson's phrase, that request for briefing would really be seeking some sort of advisory type opinion when the issue is just not present. So I wanted to make that clear. And again, I'd reiterate state water contractors' support for moving forward with the hearing and for DWR addressing this in other appropriate forums.
Thank you. Thank you, Mr. Krieger. Mr. Herrick or Mr. Rees?
Thank you. I have to say this while being polite to everybody. This is a contrived thing halfway through the hearings, right? The SOMAC and Simmons attorney was known at the beginning of the process. This comes up now, and it didn't come up as a motion. It came up as an email question, and it's unreasonable to think that this isn't some sort of a long-term strategy by DWR. Now, that may sound like I'm insulting them or something, but there's a reason they're bringing it up, and then, oh, well, we won't enforce it, or we won't proceed to that. There are at least going to be, what, 3 other proceedings, maybe 4, dealing with this topic. And again, nobody can anticipate having some court later on in some different proceeding on this same project to rule, oh, their participation's not, they can't do it. It's thrown out. However involved it was or could be, it's thrown out. And so we have one proceeding where the conflict was okay, and that grants a permit, and then other proceedings where a court says, nope, they're all gone. That can't work. I don't know how that would affect us. I don't know if a court later on can say, okay, well, we're throwing all of that out of the record. Is there enough to support the state board's decision on that? We can't anticipate that, but DWR can't bring this up and then say, oh, never mind for a while. There's something going on here that we don't know, and we're not going to be told. And it's beyond me why Mr. Ferguson is interested in making this thing go fast. We have to know if there's what the problem is and what the resolution is. So the state board attorneys need to advise you what your authority is or isn't, and then we have to decide, is there a motion? Are we going to proceed or not? But you can't have the law firm participate in every step of this proceeding, and then in some other proceedings say, they shouldn't have been there. I mean, imagine how that looks. I can't anticipate the motions or court orders that do that, but it's prejudicing everybody in this proceeding. And people that say if there's no prejudice, they're wrong, right? It's just not, this is kind of loony now. If DWR, there's a reason they didn't make a motion. I know I'm rambling here, I'm sorry, but there's a reason they didn't file a motion in this. Well, I'd like to know what that is, but they won't tell us. But they just brought it up as, oh, by the way, I don't think this law firm should participate. That's not how any proceeding on earth works, right? Anyway, the proceedings need to be stayed. That's all there is to it.
And that you may have just anticipated my question, which is what, so to make sure I understand your position, that there should be a stay of these proceedings. Well, I guess I wasn't quite clear whether you think that I should, I guess your recommendation is that I should investigate whether or not I have authority to act on DWR's objection. I think there is an objection lodged, which is what we've been talking about. And if I do not, that I should stay the proceeding pending DWR raising the issue in a parallel proceeding in court? What is it that you think I should do?
In my opinion, the proceedings need to be stayed. And then you need to come, in my view, you need to come back to us and say, the attorneys for the administrative hearing officer's office have said that I have the authority to rule on this. That could be wrong or right, I don't know. But and then if you have the authority, then it's up to you as the hearing officer to say, okay, now I'd like you people to brief on whether or not I should continue or not, given that we have these issues. But the first issue, the threshold issue is, do you have the authority? But this proceeding should not go forward until the issue is resolved. You may choose not to resolve it, but that's your choice, but it has to be resolved. We don't want some outside process later, year or two down the road, shutting everything down and making it all confused. We want it resolved because this is disqualifying a huge law firm that represents a lot of interests from proceeding in the, arguably the most important water rights hearing or application here, petition, in the last 10 years. This is a big deal. And to say all of a sudden they can't and all their clients aren't represented in the proceeding or shouldn't have been, that's a mess, a big mess. So yes, the proceeding should be stayed. Your attorneys need to tell you whether you have the authority to answer this or not. And then we can talk or proceed or brief after that.
So Mr. Rees, a follow-up. Let me think. Hold. I'm going to come back to you. I had a thought.
That's quite all right. I
spent
the whole morning on a tour.
I lost the air in the room. Hold on. Let me look at my notes here. I know. Here we go. If DWR were to withdraw its objection in this proceeding, would that resolve the issue from your point of view, where there would be nothing before me and we would go forward?
I don't think so, because once they've raised it, that means it's always there, right? There's like people said, there's consistency hearing, there's water quality hearings, there's challenges to the geotechnical thing. There's all sorts of stuff that's going to go on. So if they're asserting that there's a potential conflict of interest or an attorney-client privilege breach or whatever it really is, we don't know. You can't have one. I don't think you can have one thing go forward if all the rest of them are going to turn around and go 180 degrees the other way. I just don't. Again, I keep saying this. There's unanticipated consequences here if we're the only proceeding where this is not, resolved. It has to be resolved.
How would I resolve it if there is no objection?
I think everybody's objected already to their bringing the issue up.
Okay, so someone would file a motion and then a motion to stay, something like that.
Yes, and
who might file a motion?
Ask them why they didn't file a motion to do this. Why didn't they do that? We don't conduct business by letters or email.
Would it be better if this? I mean, let's say DWR files a motion. Does that resolve? I mean,
that means it has to be resolved. And again, I don't mean to sound critical of anybody, especially you, but we're not trying to resolve this. We're trying to get a decision, right? We're not trying to figure out what's agreeable to Mr. Ferguson or his clients or my clients or DWR. We're trying to get decisions. And so this is a difficult decision. If they've brought up an issue that will disqualify a large law firm that represents multiple huge agencies, that has to be resolved. They can't.
Why, if it doesn't affect my? If I mean, just humor me.
That's all right.
If we can go forward and in this proceeding and develop a record and the protestants all have their choice of counsel and we're going forward and the State Water Board can come to a decision, doesn't that we got to a decision, right? Isn't that?
Well, yes, but again, if I'm just making it up, 3 or 4 other proceedings that rule they can't participate, what are the consequences? What are the unanticipated consequences of, well, one proceeding that granted them a permit was allowed to go forward because it didn't address the issue of this conflict that would prevent some people from being there. Just because we think we've solved 1/5 of the issue of the problem, whether there's a conflict or not, none of us here know what's going to happen with that, right? I mean, it's unrealistic to think that somebody else, if this is appealed, won't say, well, there was a conflict, they shouldn't have even been there. And then the other side will say, oh, well, we waived the remedy to that conflict. And the person who files a petition or objection, whatever, say, I didn't. You know, I'm prejudiced. I'm a
But why would
contractor.
they? And that is my question. How would they have standing to do that?
Well,
And maybe they do. That's what I want to know.
I don't know that they do, but the people that pay money that are going to pay the money that's going to build the tunnel, right? I would argue that they could figure out how to have standing, especially when they're participants in the hearing.
I see. So your concern, and maybe so your concern is that a party that the State Water Board will come to a decision. I'm just trying to think of like the universe in which this setup that you've talked about would actually happen. The State Water Board denies the petition, and then the party who supports the tunnels files an objection, seeks to invalidate that decision based on the participation of the SOMAC firm. Is that what you're thinking? I'm just trying to think of the scenario where this concrete
That's a possible scenario. The other scenario is the petition is granted. It gets appealed, right? And on appeal, people reference things in the record, right, to make their arguments. That's how we do it. And we try to argue whether this is generally there's substantial evidence or not. And then somebody else says, well, I was there. And they deferred answering the question of the conflict of interest. And now these people are citing stuff that shouldn't have even been let in the proceeding. So how does the court rule on that? We don't know. That's why we don't want to create that situation where we don't know what's going to happen. What the court says, yeah, this 20% of the record shouldn't have been there. And then they'll decide whether or not that record still had enough to support the decision. What the heck?
So your concern is this is not, but if the waiver were broader, if state water contractors, and I'm just thinking this through, if others who support the tunnels also waived their remedies, and I know you don't think we should split the baby, we should, but does that address this issue?
No. If we have 3 or 4 or 5 other judicial hearings not coming out of this process, but other processes that say that law firm shouldn't have been there, that's a conflict of interest, so their participation, if any, can't be used or anything. Again, I don't know how to anticipate the consequences of that, but it's hard to imagine that there are all parties out there would say, okay, well, we'll let that one go, the state board hearing, and then the other ones will make sure that doesn't go. It's
But I'm still not. So you're concerned that a court reviewing an appeal of the State Water Board's decision might look to the determination of a conflict of interest by another court and on its own motion decide to eliminate some of the evidence, even though nobody raised an objection to it?
No, that's not what I said.
Okay. I'm honestly trying to understand.
Well, I'm sorry if I'm being confusing, but you just said it as your example there. What if a party to these proceedings was nothing to do with the waiver of part of the problem, apparently, says, all these people are in their briefs are citing all this information that was developed by the SOMAC firm. That shouldn't have been in the record, and I was prejudiced by that. The hearing officer didn't address that issue, and now appellate court, don't look at that. Don't look at that in your appellate review. But again, we can't anticipate all of the issues. And I have to say, I think that's why it's being handled this way by DWR. Have they answered the question of why they didn't bring this up in a motion at the beginning of the proceedings? Have they answered that? Why are we in this position?
I'm still puzzled why you want a motion. We could probably get a motion. Do you want a motion?
You can't. Well, what does it mean? What if I send a letter to you that says I don't like somebody and I think they did something wrong, and I'll waive that. That's not how it works. This is a judicial hearing, right? It's quasi-judicial, but you don't send letters to the judge and say, I've got a problem, maybe. If you got a problem, file a motion. Why wouldn't they have done that?
But that sounds to me like you're suggesting I shouldn't be acting at all. We should just proceed. We should just go forward.
No, because they've brought the issue up. They just didn't bring it up officially.
Oh.
Why do we want to taint the rest of the proceedings if SOMAC shouldn't be here?
All right. Thank you, Mr. Herrick. I do appreciate this.
I'm not trying to be argumentative, but it's
no.
It's really a bizarre situation to me that we're spending time on a resolution between two parties that's not based upon any motion to do something.
I completely agree. But I think you're asking me to do something. So
my recommendation is to stay the proceedings. First would be an opinion by your lawyers, if you can decide this if necessary. They don't have to say decide it if necessary. And once we determine if you have the authority or not, then we would do this again. We would have a discussion about, okay, now is there something that you need to rule on? Is somebody going to make an objection or file a petition or blah, blah, blah. But that's all of that is after we know whether you have the authority. And again, if they think there's a problem, they should file something in a court to say, please direct any ongoing proceedings that this conflict exists and they shouldn't do that. But to preserve it for some things and not for others is, I think, inappropriate.
So, Mr. Herrick, just a smaller point. You mentioned the AHO's attorneys several times, and they can be quite helpful. But shouldn't I ask the parties for a briefing on this? I mean, judges have questions about the scope of their authority and jurisdiction all the time, right? And you have the parties brief the issue.
I do agree with that. I didn't mean to exclude that. It's just that when you get all of our briefings, that may not necessarily affect your attorney's recommendations to you about what authority you have. In other words, somebody can make a really good argument, and then your attorney says, no, that's Mr. Herrick's an idiot. Don't go what they said. So I think that's the ultimate decision. But yes, I think briefing by the other parties is helpful. I think I need, if I may, I need more than 2 working days to brief. But that's your call.
No, noted. Thank you. Mr. Kelly.
I won't say anything else. Thank you.
Thank you, Mr. Herrick.
Yeah, thank you. I mean, what you're in an unenviable position. I think the reality is that DWR has objected to an alleged conflict, and in an email today, DWR has again alleged that they believe that there's a conflict that jeopardizes the integrity of this proceeding. And so, as a judicial officer, what, if any, obligations do you have to protect the integrity of a proceeding that you are overseeing? And I think that's the question. Maybe in response to a question that you asked, Ms. Meserve, I think that part of the issue is, and this may or may not be solvable by DWR's waiver for evidence in all proceedings, but if somebody developed cross-examination testimony, let's say, of a DWR witness that another party wanted to use in a separate proceeding, and DWR then objected, it is perhaps unlikely that the party would be able to solicit that same, perhaps damning testimony from a DWR employee in a different proceeding. And so simply establishing a fact or that evidence in another proceeding isn't always possible. And so, that's why we do this. That's why we do these proceedings. That's why people take oaths and all of that stuff. And so that's just something to consider. But the bigger question is, with these allegations now, what should you as the administrative law judge do? You have the authority to conduct these proceedings. You probably have the authority to issue something akin to an order to show cause or a request for information to support those allegations. But allegations like that shouldn't be taken lightly. And so, there are some significant questions, and it's not that there's nothing pending, because there's an objection and an allegation of essentially of wrongdoing by a party to the proceeding.
Thank you, Mr. Kelly.
Thank you.
Ms. Desjardins.
Yeah, I just wanted to say, bumping back up to due process, I think Mr. Kelly articulates clearly what process is due in this hearing, given that the integrity of the entire hearing has been challenged. And I think that's the question. You could potentially brief that separately in the issue of jurisdiction separately from the actual substantive issues. And that might be a way to get to the issue of, as Mr. Ferguson raised, what needs to be briefed. And I also would like to say regarding Mr. Herrick's concern is that there are a number of closely related proceedings. They're not entirely separated. The consistency hearing, the Water Board's Clean Water Act certification, there's a number of closely related proceedings. This does potentially affect the others that are related. All of it is related to the public interest determination. So I don't think you can just pull one out and say, oh, well, that's only respects this. To the extent you're assuming there's going to be a Clean Water Act certification and this could affect the record for that, or there's going to be, a Delta Plan consistency determination that's going to affect the record for that. I don't think you can just isolate this proceeding completely from other proceedings. So I do support the request, to preserve the integrity of the proceeding and to make necessary determination about what's necessary to preserve the integrity. And if you have the jurisdiction to take the necessary actions to preserve the integrity. If you do not, then I think the best thing to do would be to urge DWR to resolve it by, for example, seeking an injunction in Superior Court or whatever to resolve it expeditiously. Thank you.
Thank you, Ms. Desjardins. Mr. Ferguson, please. Oh, you're on mute.
Keep doing that. And with respect to the integrity of the proceedings, we fully realized DWR is again claiming that there's prejudice and did so in their email at about 12:30 today. But we've heard those claims for the last 2 weeks, and frankly, from our standpoint, those are just claims at this point. They haven't backed it up with any sort of formal motion, any evidence, and haven't asked you for a specific action with respect to those issues. So I don't think there's a question for you to respond to with respect to the integrity of the emotions of the hearing, simply by them continuing to raise unsupported claims about a conflict. And certainly, we would like DWR to agree to more and agree that they won't raise this in other forums, but we are asking, we're reacting to what they're proposing today with respect to a waiver of this issue in this proceeding and any appeals. And as I've stated a number of times, we're prepared to not stand in the way of this proceeding moving forward. We recognize that there's maybe an issue you want to address with respect to third-party issues, and can appreciate that, but I'm not certain that that's necessary as well. So that's where we stand at this point.
Thank you, Mr. Ferguson.
I'll throw out one more idea. There was some conversation about the objection outstanding. I mean, I don't know if this would change DWR's proposal, but you could simply overrule the objection and we could move on. DWR takes the risk that they would have to raise it later. The issue is, though, that they've waived the right to raise this issue in the future. So that would at least allow us to move on and put the issue to bed, and they would bear the risk of that.
Thank you, Mr. Ferguson. I think that was similar to the discussion we had earlier about finding that there had been a waiver of the objection, essentially. So I think I understand that approach. If we can please elevate Mr. Moore so he can come on camera with the rest of us. And Mr. Moore, you're welcome to come on camera and off mute.
Well, perhaps we can hope for an actually clear resolution that provides a clear waiver that provides a conclusive resolution. That is precisely what you pressed DWR on before, on which they could not give a clear answer, which is telling. So I'm afraid that at least as things stand, the Pandora's box that Mr. Herrick and others, I think, have spoken to in great detail is real. And it third-party issues are particularly important in this type of proceeding involving the public trust and public interest, among other things, and a relationship that you have acknowledged in your orders with an apparently forthcoming separate extension water rights proceeding. Beyond that, my colleagues among the protestants have already chronicled the numerous areas in which there could be an enormous tangle if the issues are not are left hanging here. But it is not a stretch at all. In fact, it is highly likely that something is going to blow up. That does not require an advisory opinion, and it is not involving any wild speculation. I'll just mention one other type of proceeding that is related that I believe was in Mr. Keeling's list. We have not one but two pending validation actions on Delta Conveyance bond issues, in which there are interested parties on both sides of the Delta Conveyance issue, and on which, if matters that could have been raised in the proceeding are not raised, they can be deemed forever immune to collateral attack. So if I support what Mr. Herrick and others had to say, that if this is not squarely addressed now and not as distinct from finesse now, it's not a matter of speculation or getting into a head-scratching advisory opinion. It's a huge can of worms that will come back to bite us later and make this proceeding much more grossly inefficient in addition to the legal vulnerabilities mentioned.
Thank you, Mr. Moore. At this point, we've been going on for a while. I think there are numerous different positions. One of the interesting pieces here, right, is that there is certainly not one or two, or I think even three positions on this. There are a number of them. I think it only reaffirms the need for briefing, at least with respect to some threshold questions, and I want to keep them narrow because I am cognizant that I mean, it's optional briefing. You don't have to respond, but it's your chance to weigh in on this issue. I also am mindful of further delay. We had initially planned, I mean, further delay if it's not necessary, depending on the outcome of the briefing, right? We're still, unfortunately, we still don't have clarity. I think what I'd like to do to give us at least one more day, this is what I'd like to do is tee up some questions for you in writing. I can give you at least 24 more hours, Wednesday at 8 a.m. We could reconvene we could take May 1st off calendar because we had a thought that we may not be able to conduct May 1 and 2 anyway. We could reconvene on May 2nd to see if as needed. And that would give you an additional day. And I don't think that would put us behind. I mean, setting aside the possibility that this could go a different way and I could come to the determination that I have authority to act on certain issues and we need to stay the proceedings. I've certainly not made a decision. But I don't want to delay this if it then turns out that there isn't a basis for doing that. So that's what I'm looking at, is that we'd have briefing due Wednesday at 8. I'm going to look to the room in the moment. Wednesday at 8, we'd reconvene on May 2nd. We'd take May 1st off calendar. Ms. Carroll, I see you have a hand.
Thank you, Hearing Officer Kinsey. I'd like to encourage you to keep the May 1st date rather than the May 2nd date. I'd also like to request that in addition to the page limit, that we also be given a time limit for argument if you are going to be hearing any argument on these issues. I think we've taken an extensive amount of time to reiterate the same points over and over, and DWR has had to sit and wait its turn while it's been maligned. We brought this up because we really do believe in the ethical standards of the practice of law and the duty that we have to clients and former clients. We've already said that the reason we didn't file a motion and that we're not bringing this and that we're willing to waive the remedy in this hearing for these purposes, for appeal and litigation, is because we're trying to avoid delay, which obviously we have not succeeded in doing. So I really want to say that if it requires resolution, we would like some procedures to resolve this as quickly as possible.
Thank you, Ms. Carroll. And just to follow me with the May 1st, May 2nd distinction, I mean, what I was thinking about is if we reconvene, I guess it's anticipation that we may have an additional extensive discussion as we did today. But my understanding is that panel 3 is not available on May 1st, or at least one of the witnesses, Dr. Greenwood, is not available on the 1st or the 2nd.
Yes, I'm sorry. Maybe that's my confusion, is I was thinking of reconvening as this group, not with our witnesses. So if you're saying reconvening with the witnesses on May 2nd, I'm fine with that. Well, actually, no, I'm sorry. They're not available, so we would have to lose May 2nd.
Well, May 2nd would be, we still have panel 2.
We still have the rest of this panel.
Yes.
I'm losing time. Yes, we could bring back panel 2 on May 2nd.
Understood. What I'm thinking about, though, is that if we need to discuss these issues, I need to have time to read your briefs and think about them. And one day may not be enough, although what we could do is reconvene in the afternoon on May 1st. I could keep a Wednesday 8 a.m. briefing deadline, and we could reconvene at 1 p.m. on May 1st, not with witnesses on this issue. Mr. Moore, please.
Forgive me for requesting that you reiterate, but I'm afraid I temporarily lost audio at, I think, precisely the point in which you were articulating the relevant dates that are coming up. So I wonder if you could clarify that.
Absolutely. And we're still I have not made any final, but this is where we are, is that I'm considering having a deadline for briefing at 8 a.m. Wednesday morning. I believe that's the 30th, that we would reconvene on May 1st at 1 p.m. and without witnesses, that we would not get to panel 2 witnesses. And then if the hearing is to proceed, we would return on May 2nd with the panel 2 witnesses and finish, hopefully, cross-examination of panel 2. Those were what I put. And then in addition, I was looking at a 5-page limit on briefs from those who are not DWR or the SOMAC firm, who I think may have additional. I wasn't going to impose a page limit because I think the position is different and there are fewer of you than the other protestants. I will think about the request for limitations on oral argument, if that's what or oral discussion on May 1st, to make sure we can move efficiently. But I had not come to a conclusion. I think that's where we are. And I'll look back to you, Mr. Moore. Did you have a follow-up on that?
Perhaps I'm simply being dense, but wouldn't precisely the issues that we apparently will be briefing, which sound like they will be demanding ones, affect the propriety of moving forward with the panels as previously scheduled?
Correct. So May 2nd may or may not proceed.
Okay, sorry, I think it's just me being thick, so I'll stop it at that.
I'm sure you're not. Well, the question is, when am I going to rule? I mean, in the interest of efficiency, these issues are, I'm not sure what I'd be ruling on, and maybe that's the point about the advisory opinion, but I'd like to see the briefing first. I'm hoping that the briefing will lend a great deal of clarity, although these are difficult issues, so maybe not. Ms. Tabor, thank you for being so patient.
Thank you. I just want to confirm that all of these details regarding the briefing will be memorialized in a written order from your office this afternoon, given the short timeline.
Yes, Ms. Tabor, I hope to have it done this afternoon. I would like, I will work as efficiently as possible. If not this afternoon, then first thing tomorrow morning.
Thank you.
And I'll be working on it this afternoon. It's just making sure, you know how it is. You need someone to proofread.
Yeah, oh, no question. We covered a lot, and I would appreciate seeing it in writing to make sure everyone is on the same page, including parties who are not able to attend this afternoon.
Understood. Thank you. And thank you, Ms. Tabor. Are there any other issues we should address now? Mr. Moore, please.
I appreciate you clarifying that we'll get this in writing, but in the discussion today, Mr. Herrick had made the suggestion of, I think, a two-phase approach to briefing, where the threshold question of your authority would be in the first one. And I'm just wondering if you, just so we can plan for it, if you have a sense today of how you're intending to proceed with what we will get in writing, as far as the scope of the briefing.
So, and thank you, Mr. Moore. Just to be very clear, I certainly wasn't intending to invite briefing on the substantive underlying question of whether or not there is a conflict and those types of issues. What I intend to focus on in the briefing are the issues that I raised. I need to think about it a little more. I think it will be the scope of my authority. I think that would be helpful. Whether or not there is an actual outstanding issue to be resolved. I think I raised some questions about third-party standing, both from the point of view of those who support the project and those who are protesting the project. With respect to this particular issue. So my intent was that this is like a threshold briefing of, do we go further, do we need to go further into a decision of, there should be a stay, or a decision of I or one of my colleagues is an appropriate person to make an initial, to accept briefing on the substantive underlying conflict issue. Mr. Ferguson, please.
And just quickly responding to the issue you just raised about scope of authority, I would hope that you'd be able to articulate what that scope of authority would relate to in terms of what type of action do you have authority to take? Because it's unclear to me when we just talk generally about scope of authority, what action you're talking about. So if that's possible, that would be great.
Yes, thank you, Ms. Ferguson. I will attempt to do that. And also I will tell you now that I'm inviting comment and briefing on that question. So yes, I will try to articulate that clearly. Ms. Desjardins.
I just wanted to briefly respond to the comment about the long discussion today. I think you were expecting a report back about the negotiations, the offer of a unilateral condition by DWR. It wasn't noticed in any way. The parties didn't have a chance to read it or think about it. And so some of the extended discussion was all of the attorneys and myself representing myself debating it in real time. I mean, it takes more hearing time when things aren't brought up in an orderly manner. I appreciate that you urged the parties to resolve it, but just suddenly being hit with this and getting an email in the middle of the hearing, that's partly why it turned into a long discussion, because we were thinking it through as we were talking. Thank you very much.
Thank you. All right, at this point, I'm looking at a last call. My intent is to adjourn for the day. I will work on getting instructions in writing to you all of you as soon as possible. I will look forward to reading your hopefully very helpful legal briefs on my questions, and we will reconvene on Zoom on May 1st at 1 o'clock. Is there anything else we should address before we adjourn for today? All right, with that, thank you very much. I will see you on May 1st.